now sitting at Boston within for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Thank you, Dana. Good morning to you all. My name is Judge Desmond. Welcome to the Massachusetts Appeals Court. To my right is Judge Walsh, and to my left is Judge Toone. We'll be your panel for the 5 cases that we have on our list today. Some of you may have practiced here before, but for those who have not, we know that there's 15 minutes per side. There's no rebuttal. We've read your papers. We're familiar with the facts. We're familiar with the law, so you need not go into length about the facts, but of course it's your time to use as you see fit. With that, we'll call our first case, which is Commonwealth versus a juvenile. This case is partially impounded. 23P0473. Attorney Barnwell.
Good morning, and may it please the Court. Hayne Barnwell on behalf of the juvenile. I plan to focus today upon the motion judge's erroneous denial of suppression with regard to the juvenile's subsequent admission that necessarily flowed from his first admission coerced from his sister. In particular, this Court's decision in Commonwealth versus Hand, which issued after full briefing in this case, is dispositive on 2 major points. The first is that the Commonwealth can only now rely on the stream of events doctrine to justify admission of a later presumptively tainted statement. And the second is passage of time between the 2 statements. Although it's not a decisive factor all alone, it is a significant factor.
So here we're talking about an hour passed from the first statement to the second statement when the officer arrived. Is that Officer Botiero?
About less than an hour. The judge does not make a specific finding as to that. However, I think it's fair to infer from the record that it's in the light most favorable to the Commonwealth, if the Court's going to go in that direction, it's less than an hour. And also the motion judge found that it was, she did not find the lapse in time significant. So we do have that finding.
Do you agree that at the time that he came out and made the statement, nobody was really talking to him, none of the questions were being directed to him?
No, well, he did testify, and again, she didn't make a finding either way on this, but she did not discredit him. The juvenile did testify that the sister was sort of being aggressive towards him at the time and barking over at him, but Your Honor is correct that there was no specific question, put to him at the time. However,
the officer was talking to his mom at the time that he came out and made the statement.
Correct, and that was one of the major legal errors that she made, that because he was essentially spontaneously saying this, that therefore that means it was voluntary or that there was a break in the stream. Although the break in the stream doesn't really nicely fit onto that. But the legal error there is, what she missed was Commonwealth versus Meehan, or Meehan, if I'm saying that correctly. In Meehan, the SJC reversed the motion judge finding that exact thing. The motion judge in that case found, well, it was 3 hours later, the police aren't questioning him anymore, the mother and his family come to visit him, and he just blurts out, Ma, I didn't mean to hit her so hard. And then he also says, I'm sorry, Mom. And the motion judge in that case found, well, because that was spontaneous, no one was questioning him, he just blurted it out. I can find that subsequent statement, though the prior statement was coerced, that subsequent statement is now voluntary. And the SJC said, no, the spontaneity of the statement is not enough to insulate what happened before. And Commonwealth versus Hand is also instructive. It's a bit different, but it's also instructive in this way. The defendant in that case had at that point come home. He was safe at his home. I think he was alone at the time. The police were no longer there. He had over an hour to calm himself down. He's the one who picked up the phone and initiated that conversation with his pastor. He didn't have to do that, but he did. And then the pastor asks these who of course is friendly, whereas the sister in this case is very hostile, but in any case, he's talking to his pastor. The pastor isn't asking him, what did you do? The very open-ended question was like, what's going on? Are you okay? And he essentially volunteers the information as well. And the court still found that's not enough to insulate from all that happened before. The other thing that the motion judge does not find, which is critical when we're talking about stream of events,
Can I interrupt for a moment? Because it seems to me that the cases that you're comparing to are different on the facts. And in other words, you would agree there's no police misconduct here, correct?
Correct,
Okay.
yes.
So if we were to agree with your theory or your position, then a police officer coming into any scene who would have really, he or she would have no idea what was going on, and there may be a brother or a sister or a neighbor or anything else that had an event with a defendant, that the statements later should have been suppressed. I guess I'm having a hard time understanding from this set of facts when there seems to me two separate kind of events.
So Minck is instructive on this. Minck instructs us that whether the coercion is flowing from the civilian or flowing from the police, it's equally offensive to due process to allow that statement to come into trial. So really the only question is can the Commonwealth prove an intervening circumstance that breaks that stream of events? So even if the police have no involvement in that, it's still upon the Commonwealth to prove that there is an intervening circumstance. And again, we have even less time than we do in Commonwealth versus Hand. We have less time, I think in Meehan it was 3 hours, and again, we have less than an hour here.
Well, what would be an intervening circumstance in your view, and under these circumstances? What kind of intervening circumstance would have protected, would have made the second statement admissible?
Commonwealth versus Hand, I think lists, it's really helpful, compilation of cases where like a huge lapse in time between the events. And I would also say that in this particular circumstance, given that the sister's not like the pastor, right? So the sister is a hostile person, not a confidant that he's, blurting these things out to. So it would have to be, I would suggest, passage of time plus at this point he is safe. He's not in the apartment around these hostile family members. He's in basically a safe space because you could envision a scenario where there's some passage of time, let's say, I'm just making it up, but let's say there's 6 hours, but his sister is still around glaring at him, right? That I would still argue is a problem. It's not really, everything that has happened before is still continuing despite maybe a longer passage.
So it doesn't sound like you can conceive of any kind of intervening circumstance where the officer's still at the residence and asking questions or investigating. Is that your view? Just like there's nothing that could have insulated the second statement?
Not in this scenario, because in fact, and it's not the police officer's fault, of course, that she's there. She's doing her job. She's investigating a crime. But as far as whether that subsequent statement, which is the only question before the court, whether the subsequent statement is the taint from that is now removed from the coerced statement from before, the police entering that environment is really jacking up the anxiety and the intimidation that he feels, because as the juvenile testified, my anxiety was spiking. He thought rightly, I'm about to be arrested based on what my sister's about to tell them. And the motion judge also found...
Then what does he say?
I'm sorry?
And then what does he say after that? He says that all those things were happening, and so he did what?
He went downstairs. He was in the bedroom at the time. He went downstairs. As Officer Botero testified at that point, the sister, and I'm just going to call her sister from now on for clarification, but sister is hyperventilating. She's angry. She's crying.
Did what? So he did what?
And then she barks at him. She's sort of being aggressive towards him. and she's telling the police officer, this is how I confronted him.
So he did what?
And then that prompted him to say it just happened one time.
And why did he say he said that?
He said that because he wanted to tell his side, but also that he was feeling extremely anxious and overwhelmed. She's barking at him. And as the motion judge found, she credited and found that he was suffering from bipolar, ADHD, anxiety.
No question.
And was not properly medicated. And as far as, the standing up for yourself, that feeling like I had to tell my side, note that she does not find that at all persuasive to her as far as the first statement. During the first statement, he testifies similarly. She wasn't letting me get a word in. She's yelling at me, calling me a disgrace, a lowlife.
Right, but those are different circumstances. In the first statement, the mother is speaking directly to the child. They're the only two in the room at that moment. This is a different scenario where the officer is now speaking directly to the mother and the child's in the other room. He comes and inserts himself and makes that statement. So those are two distinguishable factual situations, backdrops for the statement.
But she doesn't find that the fact that the only finding she makes is that this was spontaneous, that he was volunteering it. She does not find that, the fact that he was also having this feeling of like wanting to stand up for himself, that insulates anything or that makes his statement voluntary. That's not in her findings at all. We have very few findings here. And again, she testifies as to all of the mental illnesses he was suffering from. She certainly doesn't discredit Officer Botero or the juvenile, that this was a very volatile situation, that people were yelling, there was a lot of commotion, it's a small apartment. So there is no break. I mean, he has no safety here. He knows that he's about to get arrested. He feels an overwhelming sense of futility and stress and anxiety. There is no break from what happened before.
I see your time is running short, and I know you have another number of other claims you'd like to reach, so maybe we should move on to a different one.
Yes, and I just want to put one more final point on the suppression is that the Commonwealth does not argue that if it was error to find that the subsequent statement was admissible, that was nevertheless non-prejudicial. And that makes sense because not only did the statement come in at trial, but it was emphasized in closing argument. So I just wanted to make that point as well. So turning to, I just wanted to briefly speak about Juror 17, that Juror 17 should have been dismissed for cause. The only, I think, pertinent case that the Commonwealth...
Juror 17 seated?
Juror 17 was not seated. She exhausted one of her peremptories on Juror 17, and she exhausted all of her peremptories completely. So there is prejudice from this error. This was a 6-person jury? Correct, yes.
But you got 4 perempts?
4, yes, Your Honor.
Was there a showing, is there a showing that there was another juror that she would have exercised if she had an additional peremptory that you didn't have to use on Juror 17 that she would have used?
Juror 10 is probably the most direct one. Juror 10, and I am not raising that the denial of the for-cause challenge was error on Juror 10, yeah. But I think it's clear, she did not want Juror 10 on the jury. So, but Juror 10 did make it on the jury. So I think it's clear she would have exercised her peremptory on Juror 10. Juror 24, I suppose that's more conditional on how the juror would have answered her follow-up question. So I don't know what the case law really says about that. There might be some tension there, but I think Juror 10 is the most direct. Yep. The only case, or I think that she cites, few cases, but I think the only pertinent case that the Commonwealth cites is Commonwealth versus Rios. And in Commonwealth versus Rios, it's important to distinguish how the prospective juror was responding there versus here. In Rios, the prospective juror was responding, yes, I will be fair and impartial, quote, to the best of my ability. And so it makes sense that that's more of a figure of speech. This juror was struggling throughout the voir dire, and in a case she wasn't clear about how equivocal she was, she makes it clear at the very, very end of that voir dire. The court says, okay, well, kind of wrapping this up, let's get your sort of final answer on this. Can you set aside all these sympathies, your worst nightmare, and all these things she was saying? Can you set that aside? Can you be fair and impartial? And she said, I'm saying yes, but I don't know if I can. And that's just a statement right there, that she can't do it. She can't do what she needs to take an oath to do. And that was just clear.
Yeah, I mean, it's certainly concerning, that last statement. On the other hand, the standard for assessing whether there's an unequivocal assertion of impartiality is, we really defer to the trial judge's firsthand observations. And one of the problems is this transcript is there's a lot of inaudible comments. We're not really sure exactly what's going on through different parts of the relevant exchanges here. So I guess the question is, absolutely that last statement seems to undermine the unequivocal impartiality piece, but is there enough here to sort of say that the judge abused her discretion given all the circumstances, including that the fact that there appeared to be some communications going back and forth that we're not privy to on this record?
Yes, for two quick reasons. I know I only have 20 seconds. One is that throughout she's saying, maybe, I'll try, it's difficult, I guess I'll try. I mean, she's already equivocating before that final, statement. And the second thing is just reading the judge's rationale. It's enough that she tries. It's like, no, it's not enough that she tries. She's got to do it. Thank you, Your Honor.
Thank you. Attorney Mello.
Good morning. May it please the court, Emily Mello on behalf of the Commonwealth. I will start with the issue that my sister counsel left off on, the impartiality of the jury. So here, I think the focus is on Juror 17 and some of the things that Juror 17 said. As an initial matter, I would like to point out, as the court noted, that Juror 17 was not seated on the jury, and that in order to show prejudice, the juvenile would have to show that another juror who was not impartial was seated on the jury. And irrespective of what this court finds regarding Juror 17, the juvenile had an impartial jury. The two other jurors that the juvenile points to, 10 and 20.
Well, just the test for whether the for-cause challenge is preserved is the defendant was later forced to accept a juror whom he otherwise would have challenged peremptorily, right? It doesn't have to mean there's another separate for-cause basis. It's whether or not the defendant would have struck another juror. It's clear from this record that the defendant did exhaust his 4 allotted peremptories, and there was concern, at least with respect to 2 other jurors. So I guess, is that not enough to establish that the issue is preserved?
No, I don't believe so. I think that the juror has to, the juvenile has to show that he was forced to, he was forced to accept a juror that he would have challenged peremptorily, but was not able to because his challenges had been exhausted. But at the same time...
So that has nothing to do with for-cause.
Well, I understand the point that Your Honor is making. I think that the juvenile has a right to a fair and impartial jury. And if he received a fair and impartial jury, then there is no violation of his rights. He did receive a fair and impartial jury because he has not shown that there were any impartial jurors seated on the jury.
No, but see that I'm having a difficult time understanding that analysis when it comes to prejudice. So in other words, if juror number 17 was not impartial, and I know you are arguing that, in fact, juror 17 was, and so we don't get to prejudice, but assuming for a moment that we find that these equivocal statements show that a for-cause challenge should have been used, and counsel shouldn't have had to use one of their peremptory challenges, it appears from the case law, unless you disagree, that the prejudice is I didn't want juror number 10 or 24. I wanted one further down the list, and had the judge not erred in that for cause, I would have been able to have a jury that I molded and shaped. Not necessarily, oh, this person is prejudicial. It's that I didn't get to pick somebody else. Isn't that enough?
So I understand Your Honor's point, and I do agree that McCoy seems to suggest that, but I would just say that under our state's case law and jurisprudence, the criminal juvenile here is entitled to a trial by an impartial jury.
Well, everybody's entitled to a trial by an impartial jury. So the question that I have is the showing of prejudice simply the analysis, no, you got an impartial jury, so there's no prejudice, then nobody would ever be able to be successful on a claim.
Well,
right?
I would disagree with that, because you would certainly be successful if you were able to show that you were unable to use a peremptory challenge on a juror that you then was seated that was actually impartial. You have to show, in my view of the case law, in the Commonwealth's position, would be that you have to show that you were prejudiced in some manner.
Right.
The idea
isn't
that
the prejudice enough that I wasn't able to select and form a jury of my, and exercise a peremptory challenge to get to another juror?
So I think that's an important question. I think that if that were the standard, then all you would have to do is say, I was forced to use a peremptory, and also I didn't like the way that juror 10 looked.
Well, if you left a few on the table, then you wouldn't have the argument, but I'll leave it at that.
So it's your position that the juror was improperly struck, too bad, so sad, no harm, no foul, he got an impartial jury. Is that what I hear you say?
Not exactly. The Commonwealth's position would be that juror 17 was an impartial juror, and there was...
Talk about that. So let's focus on that for a moment. Yeah, I can be fair and impartial, I think.
So I think that I would point the court first to Commonwealth v. Leos, which is 443 Mass 770. And what they say there is that the judge observes firsthand these jurors and is in the best position to observe the demeanor and to determine impartiality. I think that a record is very flat, and it is hard to tell, especially on this record where there is a lot of inaudibles and it's not totally clear the entirety of the voir dire between the judge and counsel and the juror. I would just note that it is it's the defendant's burden to prepare an adequate record for the appeal. And I would say, again, just moving back to Leos for a moment, it depends how this was said. I understand that at the end, the juror says, I'm saying yes, but I don't know.
But even before we get to the end, the juror's talking about, this is a troubling case for me. You know, this is like the worst thing that can happen. I'm having a hard time with this case. It's like the worst nightmare. So that's the context of, I think, right?
So I would have to disagree with that respectfully. I think that what Juror 17 was getting at, first of all, I think this would be an extremely difficult and emotional case for anyone. The subject matter here is very difficult. We have a 12-year-old that is accused of sexually abusing a 7-year-old.
All the more reason we want to make sure we have an impartial judge.
Absolutely. It can be very hard to see these cases. But I think that what Juror 17 was getting at is that the whole case was sort of a difficult subject matter. And if you notice, in the context of where she says, this is really heartbreaking, she says the person on trial here is a child too. So I think that she was acknowledging the fact that this is a difficult case, this is a difficult subject matter. It's sort of sad on all accounts. And then the judge is asking her, but with that, understanding that this is a very difficult subject matter, do you think that you could be impartial? And if she says, yes, I think so. Look, we don't really know how she said it. So I think that it's a little hard on this record to say that that the judge abused her discretion in finding that Juror 17 was impartial. If there are no other questions regarding that, I would move on to the
Motion to suppress.
motion to suppress issue. Absolutely. So regarding the motion to suppress, first I do want to thank my sister counsel for filing her 16L regarding Commonwealth v. Hand, which I do think is a very helpful case for the court in this context. I think that here, obviously the first statement was found involuntary. The juvenile is woken up to his sister, who is yelling at him and sort of berating him and calling him names, etc. And he says, it only happened one time. That is suppressed. Then, approximately an hour later, the cops show up. At that point, by his own admission, his sister's demeanor has changed, that she went from being aggressive to being very, very sad. She was speaking to the police and everyone was ignoring him. At that point, he's in another room, he's in the kitchen, he's drinking a glass of water. So I think that the temperature has sort of come down at this point. The initial sort of outburst from the sister and the sister's daughter, who was about the same age as the juvenile, has dissipated. Now we have a commanding presence, we have the officer there, she's speaking with the victim's mother. We have a different situation. And I would also note that the officer told him not to talk, but he wanted to, and he testified to that. He said that he ignored that request because he had rights and stuff, and he wanted to be heard.
That happened. Did his father come and try to calm him down a little bit?
Counsel Minck, if I'm saying that correctly, in Hand, which all sort of talk about a statement that is initially tainted by being involuntary and then a later statement. I would note that in Hand, they do point out, no, the fact that the initial statement was not to law enforcement is not dispositive, but they do point out that it is a very important factor. So I do think that that is important here. In addition, in Minck, which I think...
So the statement wasn't to a law enforcement officer, but it was still to a authoritative figure, right?
Certainly.
Okay.
Certainly, I would say that even though it's his sister is obviously much older, as she has a son that is only a few years younger than the juvenile. And, the Commonwealth is not contesting that first statement was involuntary. He was woken up in the middle of the night by his sister. She's yelling at him. But by the time the officer gets there, the situation has changed. And I apologize, go ahead.
Let me interrupt for a moment. Again, I'm having a difficult time accepting that argument. In essence, since the first statement was tainted as a result of the, we'll call it aggressive behavior by the sister.
Sure.
Your argument is that because the sister's temperature changed, her demeanor changed, right? That just kind of changed the dynamic in that home. And I'm not sure how relevant the fact that the original cause of the statement being involuntary, that actor's demeanor changed. Especially in these facts where, on one hand, you want to have the strength of the argument of, they're in different rooms, people are talking to different people, and so he's having a glass of water in the kitchen, she's over here crying, that argument seems to me that they're separate, right? That there's no coercion, that there's no kind of taint spilling over. You can't get both benefits, it seems to me, to be fair, that, oh, sister is now no longer angry, she's sad, but she's in a separate room, and so he's not affected by that. If they're in separate places and there's a break, how would we even know whether he has a clue that the sister is still not pretty aggressive and angry, or she's now in a more sad and subdued state? So you want us to consider both of those as a kind of Commonwealth factor?
Yes, and it was the juvenile's testimony that the sister was very, very aggressive before, and that she then was sad when she was talking to the officer. So I take that to mean that he's in the kitchen now drinking a glass of water, but he can still hear and see what is going on. That was my understanding from the testimony. I don't believe that this is an extremely large home. My understanding is that the kitchen was off of the living room, and the officer was speaking to the sister in the living room, and he was sitting at the kitchen table drinking a glass of water that his father had provided to him.
The intervening kind of event is more focused on the demeanor and the temperature changing than the locations of the parties in the house?
I think that it's a totality of the circumstances, and it's all of those factors. It's the fact that some time has passed, a police officer has come who has sort of turned down the temperature in the situation. He's no longer in the same room with his sister. He's sitting at the table drinking a glass of water. She's in the other room. Yes, he can see her, but now she's acting very sad. She's sad, and she's speaking with the officer, and he feels the need to, at that point, speak up for himself, even though the officer has told him that he should not. And I see that my time is up. If there are no further questions. Oh, please.
I'm going to keep you going.
Yes.
Ms. Barnwell wasn't able to address this, but I just want to get your thoughts about the confusion about what was the basis for the rape charge, right?
Sure.
So there's the application, the complaint that describes conduct that's not rape, right? And then it goes to trial. The defendant doesn't move to dismiss, doesn't file a bill of particulars. I understand that. But the judge is sort of like, what's going on here? And then at the start of before the jury's a panel, the prosecutor says, oh, the rape charge refers to anal rape. And then the jury gets selected. And then the next morning, the prosecutor's like, oh, I've gone back and looked at it, and it's really the oral rape that we're talking about. And there's no objection by defense counsel, and I understand that. I'm just kind of wondering, what is the standard here for ensuring that the basis for a criminal charge is actually understood before a trial begins? And is there any concern here? This seems like a very unusual series of events where the actual basis for which the juvenile is ultimately found delinquent isn't really clarified until after the jury selection. Is there any concern here? Or how do you analyze this situation? And we're not talking about any kind of right to indictment or anything like that. Just as a matter of kind of basic due process. How should we look at this?
I think it is a highly unusual set of facts here, the way that this actually played out. The application for complaint, so when there's an application for complaint in juvenile court or in district court, there is the sort of face of the application, which is filled out by the officer. Attached to that and incorporated therein is the police report. In this case, the police report mentions that the victim witness statement is also attached to the application for complaint. So for the application for complaint here, we have that form filled out by the police officer, the police report, and the victim witness statement. On the application, there is a location to sort of describe each charge. The descriptions do not match the charges, and I would agree with that. However, I think that the onus is on the juvenile and the juvenile's defense counsel to, if there is some confusion or if they think that there is no basis for a particular charge, to address that either via a motion to dismiss or a bill of particulars, because at that point, it could have been addressed, and if there...
At what point?
Pre-trial.
Right, but at pre-trial, it seemed fairly clear as to what corresponded with each charge, right? What act corresponded with each charge?
No, I don't think so, because
With respect to the rape, anyhow.
No, I don't think so, because I think that what was stated under each charge in the application for complaint did not match the actual charging document. And if there
What was
was...
stated for the rape?
So for the rape, I believe it was, that the juvenile forced the victim to touch his penis and the victim was scared. It did not describe a rape, period. I would absolutely agree with that. But the charging document charges a rape. And if there was a concern regarding the basis of that charge, that is best addressed via a motion to dismiss or a bill of particulars. Because in a bill of particulars, specifically, we would have been forced to, which I think is a good thing, state specifically what the basis of each charge was going to be at trial. I think that would have been the most appropriate way to handle this.
So here you can see that the charge itself wasn't supported by any narrative, and now the burden was on the defendant to...
No. I apologize. Please finish.
It was on the defendant to file some papers and say, hey, I need to know exactly what acts you're alleging as to all of these charges.
So, no, I think that the confusion, and I see what you mean. I think the confusion is what didn't match was the officer's little one-sentence description that if you look at the form for an application for complaint, it has the charges, and then the officer fills in a one-sentence description. That did not match what was actually charged. However, all three incidents that the Commonwealth ultimately went forward on trial were all described both in the police report and in the victim witness statement. So if there was confusion regarding which acts went to which charges, that would have been best resolved via a bill of particulars.
So I just want to make sure, and I need to
I know, it's a little confusing.
There's a whole bunch of papers, depending on the practice of a police department, that go into the filter, into a clerk's office in the district court when an assistant clerk magistrate or clerk magistrate is reviewing for probable cause. Different from the complaint itself, right? So there's no confusion in the complaint itself with the charges and the description of the crimes. There's one piece of paper in this packet of information that juxtaposes, at best, the actions that form the basis, right? So you would agree with me, there'd be a problem if the complaint described behavior that didn't match up with the evidence. This is not that case.
Yes, exactly.
Thank you.
Yes, I think maybe that was I appreciate that. And if there are no further questions, I will rest on my brief. Thank you.
Hearing none, the matter stands submitted. Thank you both. Well done. The next matter on our list is also partially impounded. 22 P0956, Commonwealth versus Tyone John HOLLEY-HENDREN. We'll hear first. Hang on, let everybody get situated.
Good morning, Your Honors. Tara Ganguly for Mr. HOLLEY-HENDREN. I'd like to focus on the sufficiency arguments at both the grand jury stage and the trial stage. I think the linchpin here is the back and forth between Detective Bliss and that grand juror, that whole couple of pages conversation that they had
Notwithstanding that conversation, they still got a true bill, right?
Correct, yes. But his testimony is important in terms of, in terms of the sufficiency and the motion judge's decision. He says there's nothing that has been proven that they knew that there was a gun. He says that a few times in the back and forth. And then the motion judge's order specifically states, quote, "No evidence was presented to the grand jury that Mr. Holly-Hendren's scooter stealing practice included assaulting people who were present, riding, or attending to their scooters." Yet the decision goes on stating, analogizing to drug cases, saying that knowing that a co-venturer is armed may be proved by an inference that the victim's resistance could reasonably be anticipated. This is not a drug case. I agree.
It doesn't have to be a drug case, though, but isn't that the law? Isn't that what Commonwealth v. Rake says?
Yes, but, the law also says that joint venture cases are nuanced and specific, and the distinction between a reasonable inference and piling of inference upon inference is difficult. I just don't think that drug cases where, one group of dealers is maybe stealing from another group of dealers, it makes sense in that situation that one person would know that his buddies are armed. This is a case where we have people joyriding around the city at 3 a.m.
Not really joyriding, but
Well,
I'll push back on that a little bit, but go
okay.
ahead.
Riding around the city at 3 a.m., potentially looking to steal an unattended scooter.
You say potentially. I'm going to push back on that too, but go ahead.
I don't see where the evidence of my client's knowledge that Tyler Sales was armed is. I don't see it in any of what was presented to the grand jury.
What did your client know, do you think?
Excuse me?
What did your client know?
He knew that they were going to ride around and maybe steal a scooter, maybe not. That's what the evidence shows.
And we're going to get to the Facebook or the social media, not really sure what you want to call that. But there's some communication back and forth there, right? And he talks about, generally we're taking bikes that are chained, that aren't
Yeah, he talks
manned,
about having...
right? And he seemed a little surprised that, hey, wait a minute, this bike you seem to be talking about, it's not chained? Doesn't he say that? What's words to that effect?
That conversation was not necessarily specific. That conversation was, I think, before they even started. There's no evidence that conversation was regarding the victims.
Before they went out that night.
Yeah.
Before they went out that night.
And they talk about bolt cutters. I have, cutters talking about, okay, well, maybe I can cut a chain if this is There's certainly no conversation about, are you packing? Do you have anything? Do we need something? There's not anything like that.
Fair to say.
So why can't that be a reasonable inference?
Why can't what specifically?
The analogy is in drug cases, when one person goes with another and they know there may be a confrontation, that it's a reasonable inference that, given the propensity for a confrontation, that somebody will be armed, right?
Right, and
Why can't this be a reasonable inference in this situation too, given the description of how these thefts sometimes occur?
There's certainly the Commonwealth has not pointed to any cases. I've never seen a case regarding scooters, and they certainly don't point to any case involving scooters like this. There's a separate argument regarding the so-called expert and the scooter testimony, but I know these cases actually go to my trial sufficiency argument, but Commonwealth versus Baxter, Commonwealth versus Baez, 494 Mass 369.
Charlestown case, right?
Yes. Both of those cases, the SJC, and those are cases where the defendant was driving a car both before, in one case before and the other case after the shooting, which involved other individuals. And in both of those cases, the SJC said that that the Commonwealth's argument overstates their actual evidence and requires pilings of inference upon inference to conclude that the defendant knew of and shared the assailant's lethal intent. I realize it's probable cause standard at grand jury stage, but I think that same reasoning applies, and it certainly applies at the trial stage.
Has rakes and booth, is that how you pronounce it, ever been extended outside the context of robbing drug dealers?
Not that I know of.
As a, I mean, I guess, is there a limiting principle here? The logic here seems to be, well, scooters are valuable and you know someone's going to defend that. That seems to kind of apply to most robberies. So I'm trying to understand what's the, is that what we take from rakes, that sort of anytime there's a joint venture robbery that people assume that a weapon could be used because someone's going to try to defend their property, or what's your, how should we interpret that kind of line of precedent?
I think that's why it has to be so fact specific. I mean, say we're talking about a home invasion robbery. I think it's much easier there for the inference to be made that one person knows that the other person is armed if they're going into a house to potentially steal items. You know, and same thing in like going into a store and robbing someone, the other one person probably knows that the other person is armed.
I guess the other factor that the Commonwealth points to here is that this occurred late at night and that somebody would feel more vulnerable and therefore wouldn't want to be stranded, and so that was an extra factor that would lead to victim resistance.
I think that's a reasonable question, but I don't, in terms of whether, I know there was a lot of focus on you know, this was the victim's job, it was his livelihood, certainly he would want to protect, you know, his own life, obviously, and his livelihood, meaning his bike. But that's still a large leap to, if that and the drug cases are the only inference that my client, who had someone who was driving around, you know, your honors have seen, I assume have seen the video, and when you look at that video, there's a lot of argument in the case about what it meant when my client put his left foot down, and there was a lot of argument about.
Do you agree that was a very deliberate act in the video?
No, I don't.
You don't think so?
I certainly don't have a lot of experience with scooters, but I know when you're riding a bike, most things on two wheels, if you're stopped, and they were stopped at that light, you're gonna fall over.
Yeah, I get that, but I'm saying as far as seeing it on the video, did you see it on the video?
I did, yes.
Okay. So I understand exactly what you're saying, having ridden bikes myself. But in the video, it appears that it's a very deliberate act that he's making. He doesn't appear to be getting off the bike. He doesn't appear to be setting the bike down. He doesn't appear to be falling. His hands are still on the handlebars.
Right, so they drive up to the intersection, the light's red. He stops. He puts his foot down to prevent himself and his passenger from falling.
I'm not sure about that. I'm not sure that's what I see.
Okay, I think that it's equally as speculative.
We have to say the jury saw that, right?
Right.
Okay. So reasonable minds might differ as to what the jury saw.
Sure.
Or how they characterize that act.
Sure, but
and then we have the expert testimony, right, that kind of informed the jury about behavior in bike life and the culture.
Right, so could I turn to the expert testimony? So, there, you know, as the court knows, there's 5 factors that the Commonwealth the judge has to rule on those 5 factors in terms of the expert's testimony's admissibility. This was a brand new theory of evidence, theory of, quote, bike life, whatever that means. The Officer Trull was a police officer. There were no studies regarding this. No one else relied on it. There were no other cases where this had been, you know, admissible testimony. defense counsel pushed back really hard on this because this was sort of a brand-new theory of prosecution.
What's the theory?
That these people ride around trying to steal scooters, you know, scooter parts are interchangeable, it's sort of a...
Culture of bike life.
The culture of bike life, yes. But, you know, this was in his voir dire testimony, which didn't go in front of the jury, but it certainly informed the judge's decision whether to let him testify at all.
Did you say there was an extensive voir dire?
I'd say it was an extensive voir dire, yes. But he says, it appeared to me that they knew him. That's pretty speculative, in my opinion. I mean, all he did was look at this video and somehow say it appeared to me that they knew him. You know, I don't believe that any of these factors were actually met.
Oh, sorry, go ahead.
Would the testimony of the expert assist the jury? You don't think that was met?
I mean, he talked about bike life in terms of...
You don't think that was met?
I don't, no. He talked about the identification of scooters, patterns of scooter theft, movement of these people. He talked about,
You don't think
know,
any
what
of that was
happened
helpful to the jury?
No, I think that there were 3 people riding around the city, but I think it might have been different if it was like, you know, 10 people riding around, or, you know, over a couple of days, patterns of people riding around on scooters. This was 3 people riding around at 3 a.m. He's trying to analogize to various anecdotes from other cities and a movie.
Did he explain that 2 people on a bike may have significance?
He did, and I think that was prejudicial because, you know, he talks about, he calls it double riding, and says that there's a high likelihood of criminality in double riding. So that certainly goes to prejudice. But just touching on...
Can I ask you about, I agree with you, defense counsel did a good job advocating on this position, and I think that the judge took it to heart and was somewhat skeptical about this expert testimony and therefore cabined it pretty strongly. So I guess of what actually was presented to the jury, what do you think is the most prejudicial testimony that the expert provided?
I think there are 2 things where Officer Trull at one point says to the jury that everyone who rides a scooter, quote, could, would, or did commit a crime. I think that's pretty prejudicial. And when he said that there is a, quote, high likelihood of criminality in a double ride. And defense counsel did push back on him saying, you know, you don't actually know this. And he was like, essentially, yes, I do, based on I don't know what exactly. I'd just like to touch on with his testimony, the motion to reconsider, the Commonwealth's motion to reconsider, and the defense counsel's motion to strike.
So at first it was allowed, it was going to be kept out, right? And then they filed a motion to consider.
Correct.
And the judge reconsidered and brought it in.
So they file a motion to reconsider. They come in, they don't make any new arguments. They essentially just beg the judge to change his mind. That's not how Rule 13 is supposed to work.
What did the judge say when he changed his mind?
Essentially just, okay, well, I'm going to limit it to this. He didn't make any new legal
I thought that he had said
findings.
that he didn't appreciate, maybe I'm mistaken.
Excuse me?
I thought that the judge had said he initially didn't appreciate the kind of the nexus, I'll say, my word, not theirs, that the Commonwealth was trying to tie between the acts of the defendant and the expert testimony on bike life.
Right, he did. The judge was, in the prior day, when he ruled against it coming in, he was pretty strong in terms of, I don't see, I don't see the nexus, I don't see the relevance of this coming in. And then,
and then did he explain why he changed his mind the following day?
not really, Your Honor. he essentially just capitulates to what the Commonwealth wants, and then when defense counsel files the motion to strike, that's denied because he'd already made his decision. And that's not how Rule 13 is supposed to work.
I tend to disagree, because I think if you're a trial judge and you make a ruling and the next day the Commonwealth and defense counsel are before you on a motion to reconsider, or the week after, that when a judge says, I didn't appreciate X or Y, let's face it, it's about getting the decision right. And it doesn't have to be new evidence. It could be just, now that I've had an opportunity to take a deeper look into the arguments that were made and what was presented, I was wrong, in essence. One way or another. It works for you as much as it works for the Commonwealth, right? At times, the Commonwealth gets something in, you file a motion to reconsider, and the judge says, you're right. So I don't see how that's an abuse of discretion when the judge doesn't have new information, but just says, here's the theory of admissibility, and says, I didn't realize the connection.
Well, I would just point to the language of Rule 13, which talks about new or additional grounds which could not have reasonably been known before, but I take Your Honor's point. I realize that I have additional arguments, but I rest my brief.
Thank you, Counsel.
Thank you.
Attorney Slyman, the government.
Good morning, and may it please the Court. Mackenzie Slyman on behalf of the Commonwealth. Before starting, I'd like to acknowledge ADA Julie Higgins, who's with me at counsel's table, who prosecuted this case, along with ADA Alexandra Rahimi, who's in the gallery. I'd also like to acknowledge the family of Raymond Holloway-Creighton, who tragically lost his life in this shooting, who are joining us both here today in the courtroom and over the live stream. If I may, I will start with the sufficiency of the evidence argument, and I will start with the sufficiency of the evidence that was introduced at trial, just given the heightened standard burden of proof for the Commonwealth. A jury can infer that a defendant knew that his co-venturer was armed in an armed assault with intent to rob if the victim's resistance can reasonably be anticipated, because the defendant would be presumed to recognize the need for a means by which to overcome that resistance. Here, there are at least 3 reasons why in this situation there was a reasonable likelihood that that Mr. Holloway-Creighton would resist turning over his scooter.
What are they?
I'm sorry?
What are they?
Yes. The first would be the intrinsic value of the scooter.
So we're talking about an $800 bike, right? I think
Yes.
he paid $1,000 for it. I think the expert said that he valued it at around $800.
Yes, it's valued at, he valued at $800. We know that the defendant himself, the victim paid $912 for it. But I think even without those hard numbers, a jury with their life experience can acknowledge that that's a big purchase for someone that comes with significance. Second to that would be the fact that the scooter was the means of the victim being able to achieve his livelihood. He was a Grubhub delivery driver, used the scooter to effectuate that, which was apparent to the defendants at the time because of the Grubhub bag on the back of the scooter. And lastly, as has already been alluded to by the court, but the date and time that this took place. It's the middle of the night.
So looking at those 3 things, I mean, couldn't you arguably say that it's 3:30 in the morning, it's, not far from, we're looking at kind of Mass Ave, Columbia Road, right in that area we're talking about. He's by himself, he's outnumbered. Why would you anticipate any pushback?
I think because
The $800 bike.
Sure, but I think that's where it goes to why this is first viewed in the light the facts are viewed in the light most favorable to the Commonwealth, but also why this is left for the jury's consideration with their own life experience. Because to someone who has a car to drive, might have multiple cars, a scooter might not appear to have that much significance and value to someone that they would put up a fight to not turn it over. To others who have different life experiences, they might view it as, which was the case here, that it can serve as the person's only means of being able to transport themselves. And viewed in that lens, I think, we don't question with cars that there is that intrinsic value to them and to the person needing to use it at the time. I would also point the court, and I believe Justice Toone, you asked this question to my sister, but while Rakes is a case that deals with drug dealers and the inherent value of drugs, which would lead the co-venturers to expect resistance, I would point the court to Commonwealth versus Cologne, which is cited in the Commonwealth's brief. This was an appeals court case, but I think that this aligns very closely to the case here. There, it was a robbery that took place, an armed robbery that took place on the platform of the T. There, the court found that the joint venturer, who was not the principal actor, did have reason to, again, expect resistance from the victim and would thus assume and know that the principal did have a weapon on him. The defendant in that case conferred with the co-venturer immediately before the robbery and stood within a few feet of that co-venturer, acting in concert with him when they effectuated the robbery. This is incredibly similar on those facts alone. And there, jewelry was stolen. So we have this case firmly in as showing that the expectation of resistance is not only addressed.
I guess I'm most worried about. Doesn't seem to be much in the way of a limiting principle here to your argument, right? If you can infer, obviously when you're robbing drug dealers, it's not only the drugs are valuable, it's that drug dealers were probably more likely to have weapons to defend themselves. And anything worth robbing is also worth defending. So what's the limiting principle? What kind of armed robbery can exist where there wouldn't be an inference of knowledge that a firearm is going to be used?
Sure, and I think it is a fact-specific question, and that's how it's designed to be. If we were in a factual situation where they just walk up to someone on the street who's not visibly showing that they have anything of value to steal, perhaps there would be a harder showing to. There would be less factors to point to for why the co-venturer would expect resistance from someone who might be out for a jog and doesn't have anything of value on them, who doesn't have a bag with a laptop in it or a smartphone. Those facts certainly would be a harder showing, and perhaps in that situation, the Commonwealth would not be able to prove that element beyond a reasonable doubt. But that's why I think these cases show that it is intended to be a fact-specific question. And the facts here show that Mr. Hawley-Creighton was using the scooter to complete his job, that this was how he did so, that the scooter, again, itself has significant value in its cost and its, and I would also point to the...
Could you make an argument that anybody who's willing to be out by themselves on a scooter at 3:30 in the morning in a arguably tough neighborhood is not likely to just give up their bike?
I think that would be a fair inference, that the environment, the situational factors would play into that. But I think that goes to my reason of the date and time of the robbery, that it is, again, an isolated area. It's off of Mass Ave. It's 3:30 in the morning. If they had effectuated this theft of the scooter, Mr. Hawley-Creighton doesn't have the means to get himself elsewhere. And I would also push back, and I, of course, defer to the court's review of the video in this case, but I would push back that the defendant's only movement during the actual assault is just putting his left foot down. His positioning is that he is to the right of the shooter, of the victim and the shooter. So his left foot is just keeping them stable. I would suggest to the court that the video shows that he does more than that he steps off more fully and makes a movement towards the victim's scooter, which I think exhibits far more involvement in this than my sister would suggest, of just stabilizing himself at a red light and all this kind of playing out unbeknownst to him. And I think the Facebook messages here also color the context of what the lead up to this moment, and can be considered in that way as well. And that they stayed together after the shooting. This wasn't a situation, or I think it's a stronger inference to be drawn that this wasn't something where the defendant was taken aback, peels off, and distanced himself as much as possible from the shooter. He's seen on video with the shooter at 3:32 in the morning, 3:35 in the morning, and then at 4:46, over an hour later, they're still seen together, the three co-defendants driving through the city. So I think all of that goes against this suggestion, which is not in the light most favorable to the Commonwealth, that the defendant was taken aback by this turn of events and, couldn't peel away
But do the
fast enough.
Facebook messages support your argument as to inferential knowledge of a firearm? Or as opposed to just inferential knowledge of a criminal course of conduct?
I agree with my sister that that the Facebook messages at minimum illustrate that the defendant knew they were going to ride around and steal a scooter that night. I acknowledge that I think that there is a fair inference that when they were unsuccessful, as illustrated by the messages, that their plan then escalated to needing to now look at individuals who are on scooters versus potentially ones that were just locked up. But again, I don't think that fact is necessary for showing the expectation of resistance here.
In the Facebook messages, is there some concern about whether they're going to be taking a chained bike or I don't want to say abandoned, but a bike that's not being ridden or not being with anybody, kind of on its own, versus maybe not?
Sure. I think the messages exhibit a general intent to steal a scooter that night by whatever means necessary. There's certainly the messages are more specific to a back and forth of, my bolt cutters aren't working on these. Is that scooter chained? Is it not? Oh, there's 2 unchained ones at this location. So there's certainly, I think, stronger references in the messages of at least their first attempts to steal one that was not manned by someone. But I still think that looking at that conversation on a whole, and I would again point to, when you look at the timestamps that are on the exhibit itself that went into the jury, they also stopped speaking. The messages stopped going back and forth when the defendant and the shooter meet up. They stopped during the shooting itself, and they match up fairly well with when the parties are together. The messages stop. When they're separated, the messages start again.
Was the co-defendant on the back of the bike, the woman, was she charged?
She was. They both went to trial. So the shooter himself entered a guilty plea prior to trial, and then this was a co-defendant trial. Both went to trial. And just to briefly just speak on the probable cause of the grand jury standard, the same evidence went before the grand jury in terms of sufficiency there. But I would also just push back on Detective Bliss's back and forth with the juror. I think, the Commonwealth has not and did not argue before the jury any direct evidence of knowledge, and the case law that I cited in my brief acknowledges that knowledge is very hard to prove with direct knowledge, absent, some video or a recorded conversation expressing that information. So the Commonwealth has never taken the position that there's direct evidence of knowledge, and I think Detective Bliss's back and forth, when viewed in its full context, which was provided in the briefs, shows that he was expressing that. And I would say too, in his greater response to that question says, and I'm quoting here, they both admit that they saw the gun before the victim was killed. So at the very least, they knew when it was happening that there was a gun involved. So I think that any inference that he was suggesting to the jurors that there was absolutely no evidence of knowledge is defeated by this further information he provides in that context. If there are no further questions as to the sufficiency, I'll turn to the expert testimony unless the court would like me to go elsewhere. This testimony, I think, is best compared to drug recognition expert testimony. Again, drug
recognition, like testing, or drug distribution versus
distribution,
possession?
yes. And I would point the court to Commonwealth versus Miranda, which is cited in the Commonwealth's brief, and Commonwealth versus Carabello. Both of those are cases that acknowledge that judges have broad discretion to allow narcotics investigators to testify as experts in drug cases. And I think Miranda is especially on point where while the average juror may understand from common knowledge what a lookout does in general, they do not possess specialized knowledge that drug dealers often work in pairs, one to conduct the transaction, another to function as the dealer's eyes and ears. And how the expert testimony there was helpful to the jury, which is the core question about whether expert testimony should be relayed.
Well, that's not the core. It has to be reliable. There has to be methodology. It has to be an established field of expertise, right?
Of course. Sure. Yes.
It definitely seemed questionable here, and I think the judge was appropriately
Skeptical,
Skeptical,
sure. And I
yes,
think that,
and-
that's the value of the robust voir dire that took place here. The judge got to hear absolutely everything, that both sides had full opportunity to question Officer Trull about his experiences, about the test, his experiences in the field, what he was doing online, looking at spaces, all of that, and led the judge to an informed decision. And again, in his role as gatekeeper, that it was sufficiently reliable to reach the jury for their own consideration here.
And as gatekeeper, you'd agree, he didn't open that gate too wide, did he? For the testimony.
Certainly not. I think that there's an important distinction here that that the trial judge was very explicit and clear in the limitations of what the officer could testify to. And I think this takes this out a lot of other expert cases where we have like DNA experts or experts who are going to be opining on the actual evidence in the case and reaching ultimate conclusions. Here, the judge was very clear that Officer Trull was only allowed to testify about general information, about the characteristics and patterns of scooter theft.
But what about the 2 points that Ms. Gangley, when I asked for prejudice, the double riding as evidence of criminality and sort of the would, anyone on a scooter will commit a crime? I'm not sure exactly what the language is. Can you just address both those points, please?
Of course. So I would first push back on the would, and did, and I'll say, I'll quote it briefly from the transcript that Officer Trull testified. And like I said, we're a small unit, so we can only do so much, but we spend hours and hours and hours on surveillance, watching people who we suspect would, or did commit a theft. So I think that the characterization of that testimony needs to be clear, that was not an assertion that every person on a scooter is a criminal. That was certainly addressed on cross-examination, where Officer Trull admitted is not even the right word, but was clear that was not his testimony, that every person in that position does that. And I think the double ride is relevant for the jury's consideration, because I think it's similar to that Commonwealth versus Miranda case about drug recognition experts, and how the jury might think it's benign that there are two people riding on a scooter, and it very well may be, and that's for their consideration in these circumstances, is that the conclusion they want to reach. But his testimony allowed them to understand that seemingly benign behavior might have other implications or suggestions. So for that reason, the testimony was not unduly prejudicial, and the judge properly allowed it in his role as gatekeeper. I realize there are issues I did not touch on, but if there are no further questions, I will rest on my brief.
I see that your time. Thank you, well. Very well argued by both sides. Tragic case no matter what. Matter stands submitted.
Thank you very much.
Third matter on our list, 23P0450, Commonwealth versus Franklin John Pina, Jr.
Good morning, Your Honors. May it please the Court. David Rotundo for Mr. Pina. Mr. Pina was arrested after the execution of 3 search warrants, one for his home, one for his person, and one for his truck. Now, the main issue in this case is whether Mr. Pina had constructive possession of drugs located in the glove box of a vehicle he was in. The vehicle was not his vehicle. The vehicle was owned by a person by the name of Woods, who on that day gave Mr. Pina a ride to a junkyard to retrieve items out of his vehicle. So the vehicle was pulled over. Mr. Pina was pulled out.
Woods testified?
And Woods testified. Woods was granted.
Immunized witness?
Woods was an immunized witness. And now, Woods had a small amount of cocaine on him, and it was discarded by the police.
I thought that was never tested.
I don't believe it was tested. The officer stated that he believed...
The white powdery substance that they found in. But we know that the testimony of Woods alone, standing alone, can't convict your client, correct?
Right.
So then we look to more, but but we can consider what Woods says. In context, police are coming, your client freaks out, he sees him, put it in a glove box, that he's the only one there, it's his car, nobody else has been in that car that day, and lo and behold, in the sunglass case, there are the drugs. But we have more than that, don't we? And we're looking at the
Correct. Well, I would
standard of
first argue
sufficiency.
that that's not enough. And
The
the fact,
statement alone, I'd agree, isn't enough.
and I know Mr. Pina also had an amount of cash on him, and I would argue that even with that plus factor, that would not be enough.
Okay, so
Okay.
we have the statement, right,
Right.
by Woods, believe it or not, and the jury apparently believed it, but
Well, I
we
don't-
have the 1217 in cash.
Right.
We have the fact that he had what I'd call accoutrements of distribution, right? We've got digital scales, a glass grinder,
Well,
white powdery residue, the corner cut bags, and on his person, he has some corner cut bags, which could go either way, and straws. But we also have the fact that the dog ingested some amount of cocaine. Isn't that enough for a sufficiency of the evidence?
Well, first, I would argue that, where do we draw the line with regards to the plus factors, right? So here we are, he's pulled over in, I'm not exactly sure where, but, there's quite a distance away from Dennis, where Mr. Pina's home was located, okay? So he's pulled over and this search warrant gets executed on his house. And there is, I can see there is paraphernalia found in his house. We do have some other evidence. We do have that the police had a GPS on his vehicle for a significant amount of time, which never showed that he was actually driving the vehicle. It was just an electronic scan that his vehicle was going certain places, making stops, and going to Boston for short periods of time. That evidence came in as well, and the most significant evidence, in my opinion, is that the evidence that was originally severed from the case, the evidence of the dog ingesting cocaine 2 days earlier at the defendant's residence. So first, I'd like to say that, for a constructive possession case, the inferences have to strengthen the link between the defendant and what's located and the drugs in the vehicle, the drugs in the glove box. And in this case, and it was extremely difficult for me to find cases on point because these facts were very unusual. Never did I find a case, it was always the type of cases where, you could link the defendant to something in the vehicle, in these vehicle type cases where, he exhibited some types of consciousness of guilt, he attempted to conceal, and maybe some type of furtive movement. In those type of cases, they'd say, yes, okay, it's good enough to show that he possessed those drugs located in that glove box. My argument is these plus factors are very remote. How can you say that it contributes to whether he knew drugs were in a glove box, with 20 miles away, some paraphernalia was found in his home? Now, so that's essentially our argument. And more so, our argument is if the jury had was in any way, on the fringes of finding my client guilty, the fact that the dog ingesting cocaine 2 days earlier was extremely prejudicial. It was subject to the motion to sever. It wasn't. The prejudice outweighed any judicial economy of having that evidence in the case. And I'd like to point out...
Moving on from the sufficiency of the evidence argument to the motion to sever?
The motion to sever was argued. It was allowed initially, and then it was denied. It was denied initially, and then it was allowed. But what I'd like to point out quickly, and it's very, very, very important. In closing, the Commonwealth hammered this home Now, let's talk about the dog who didn't just die. You think the dog was suffering at 9 a.m. when she was foaming at the mouth of cocaine ingestion? Why is all this relevant? Well, why is this relevant to whether or not Frank Pina trafficked cocaine, possessed a fire? On and on and on. Sympathy to the jury. I mean, most people love animals more than people. I mean, that evidence should have been severed out of the case.
It wasn't part of the case that they're watching your client. They believe he's a drug dealer. They're watching. There's an investigation going on. I mean, this isn't just, they come upon him. They're watching him. The dog ingests the drugs, and then the next day, he fits the pattern again. He's back at Franklin Park Zoo, wherever he is, coming into Boston, going right back.
Well, they never ID'd him anywhere.
What's that?
They never ID'd him in the vehicle.
Well, not him. His truck, or whatever the movement is, phone, goes back to Franklin Park. It's consistent with the pattern that they'd been seeing all along. And so they presume that he must have been, the dog must have eaten the cocaine, and so he must be re-upping, I think, is the inference they want you to draw from that. And so they're watching him again, and they realize that he's getting a ride from his buddy. They're watching the truck. I mean, he's not the back seat passenger. He's not the driver of the truck. He's the front seat passenger within arm's length of the glove box. Right. So, inferentially, why is that not enough?
Well, I think equally, the driver of the vehicle, who on cross-examination, one of the police officers testified that the driver was in the past subject to potential investigation for being dealing drugs. So, I think the driver's, it's equally inferable that the driver may have something to do with it.
But we're not looking through that lens, right? We're looking at this stage, the sufficiency of the evidence, right? And so, in the light most favorable to the Commonwealth with all reasonable inferences. So, if you're in front of a jury, that might be the winning argument. When you're in front of the appeals court, the standard of review rules the day. So,
correct. I understand your position. So I'd like to kind of backtrack and point to the substantial risk of miscarriage of justice argument, which I believe stems from the allowance of the cruelty to the animals charge. And I think that I would have to argue that the evidence of that dog ingesting cocaine flipped this case. And I think that made a significant difference in the jury's determination of the facts. The evidence of the dog, and familiar with my argument with regards to why it should have been severed.
So let me make sure I'm clear of this argument. Is it the evidence of the delay in getting veterinary help that you say so prejudiced your client, or the evidence of the ingestion of cocaine by the dog? Which one?
The evidence that was presented that the dog ingested cocaine, and the Commonwealth's argument in closing on how they utilized that evidence in closing to hammer it home that, hey, this dog ingested cocaine, he's a drug trafficker. Not in those words specifically, but it was extremely, that type of evidence was extremely prejudicial. So, and the reason, the motion to sever the cruelty to animals, first, it was, as Your Honor just stated, it was not based on, the cruelty charge was not based on evidence of ingestion, but it was based on the delay of getting the animal to the vet.
So I see those as two different species of types of evidence. One on the cruelty to animals and the delay, which I have some questions, particularly for the Commonwealth, but on the issue of the ingestion of cocaine. And when we look at a motion to sever in the same kind of course of conduct or the same evidence connected with a single line of conduct, where this is all in the same time frame and the investigation is actually altered and the execution of the search warrant in part because if you believe the Commonwealth's theory, defendant had to go back up and replace the cocaine that the dog ingested. And the fact that now they're getting a call from the friend that the dog is sick and having to go to the vet changes, the course of conduct of this drug investigation. It seems relevant to me. Now, whether the delay in veterinary kind of treatment is a separate issue, but I'm not following your argument that the judge committed an abuse of discretion in failing to sever that charge.
Well, I think at first he ruled
or
that...
admitting that evidence, right?
That the cocaine, I think he first ruled that, he ruled first that he severed it, but then he ruled, he reconsidered it and said, oh, I didn't realize that the cocaine ingestion by the dog is relevant to count 2, illegal possession of Class B, because it was a small amount of drugs found at the defendant's home. But even with that said, I would, my main argument is the prejudicial value of the evidence. I'd like to move on to argument 3, which, with regards to the animal cruelty charge. So, Chapter 272, Section 77 applies to prescribed intentional conduct.
Have you read Commonwealth versus Russo?
I'm sorry?
Have you read Commonwealth versus Russo?
I don't believe I have.
And understandably, it came out, both the appellate version and the decision, and then the SJC took it on further appellate review.
Oh.
It's relevant, and I think strengthens your case.
Well, I read quite a few cases, but I would argue that at most the conduct was, I realize it being neglectful, someone leaving an animal in a vehicle in the heat, someone not feeding an animal, intentional conduct like that. I mean, this conduct in this case, first, the defendant's significant other and someone else in the neighborhood were the first to notice that this animal had issues. And Mr. Pina was not even present at that time. He did get involved subsequently, but I guess the bottom line, so to speak, of my argument is here, this was it was a delay in getting the dog to the vet. And she should have been, the dog should have been brought to the vet earlier. There's no question about that. But I would argue that, if you upholding a guilty verdict like this would essentially create law that criminalizes the delay in taking an animal.
What was the nature of the delay? Wasn't there some discussion about a $5,000?
Well, I think that was, that may have been part of it too. That and I think in circumstances, pet owners, if their dog eats a grape or does this or does that, they may choose to kind of wait it out versus take it to the vet and get hit with a $1,000 bill. You don't have insurance coverage for this kind of thing.
At the end of the day, it seems clear that the pet owners cared for the dog. Lovey, I think, is the name of the dog, and he eventually did put down at least a down payment or some money.
He did. He subsequently went there and put some money down. So. With regards to argument for the Guardado argument, I'm just going to, I have to concede to the Commonwealth's argument in that case with the new law that's come out on that. I believe there was sufficient evidence presented during the case.
I see that's your time.
That's all I have. Thanks.
Thank you.
Good morning. May it please the court, Rosalind L. Corey for the Commonwealth.
Good morning. Can you just start with the animal cruelty?
We absolutely can, Your Honor. I have read Russo, and I am prepared for your questions on that.
Okay. So how is it animal cruelty?
I would say that the biggest difference between what we see in this case and what we see in Russo is in Russo, the issue was, there was never a question that the dog, I think his name was Tipper, was going to pass away.
Even leaving Russo aside?
Leaving Russo aside, how is this animal cruelty?
Yeah.
So there's plenty of testimony from people who interacted with a dog or heard reports of the dog's condition throughout the day, chronicling the way this dog deteriorated throughout the day.
Do you agree that it was a big bill to care for the dog?
I work for the Commonwealth. I absolutely agree that was a big bill.
Okay. And so, being a government worker myself, I agree with you. And so, that being said, do you agree that there was no guarantee that they were going to be able to save the dog?
No, I do.
I thought the evidence was they had a better chance had they treated it earlier, but there was no guarantee.
That's what I'm saying. There is no guarantee, but I would argue that there is no guarantee for any medical procedure.
So for any family who's, trying to make ends meet and may not have $5,000 to take care of their pet, sadly as that may be, are we saying that's cruelty to animals?
No, not necessarily.
So why is it necessarily cruelty here?
So again, the testimony in this case made clear that there was no action taken, even asking a question as simple as, how do I induce vomiting in my dog? No steps were taken to address any of the suffering that this dog was put through, and it did continue throughout the day, and the dog did deteriorate. By the time she was brought in, I believe the veterinarian testified that she was suffering from heat stroke as a secondary condition to the ingestion of cocaine. She developed further and more acute symptoms and was put into more pain because of this delay in care, delay in any action whatsoever. Even, I think, if you look at the transcript, I believe it's volume 4 of the transcript where Cora Fellers testifies, and on page 37, she does state that she is the one who said, I'm taking this dog to the vet. She is ultimately the person who made that decision. The defendant and a neighbor's son did put the dog in her car, but she's the one who made that call ultimately and drove the dog.
Okay. So we agree, though, that there's no duty to treat, in the Commonwealth of Massachusetts, an animal.
There is no affirmative duty.
Despite some significant pushback by the legislature, there isn't. In animal cruelty, when you read RAUSEO, that last portion of the statute is what we're talking about here, that very specific knowingly and willfully. And so you have to prove as a Commonwealth that the defendant consciously authorized or permitted something that the defendant was aware would subject an animal to unnecessary torture, suffering, or cruelty. And here's where I think you might have a problem, I'm just telling you right here, that the defendant intended both the underlying action and its harmful consequences. The defendant must intend the animal to be subjected to unnecessary torture, suffering, or cruelty. And in RAUSEO, that willful aspect wasn't there because there was no evidence of, or even a reasonable inference that the defendant intended for the dog to unnecessarily suffer. So Justice Desmond hinted at it earlier, or not even hinted, say quite the opposite happened here. They took the dog to the vet. The defendant paid for some treatment. And now I read through those medical records quite carefully, and there was, and I can use my common sense when it comes to veterinary calls. If you say my dog is walking with a little limp, you should bring him in. My dog sneezed, you should bring him in. There was no testimony in the trial, there was no record evidence that would show that the defendant intended by the delay to subject that animal to unnecessary suffering, unnecessary torture, or unnecessary cruelty. I think your case would be stronger if there were some notes in the record that says, if you don't bring this dog in, this dog is going to suffer like nobody's business. It's going to be overheated, its heart is going to go up, it's going to stroke out and seize, and you need to bring it in. You might move a little closer to differentiating on the willful, but tell me how, with this set of facts, you sustain a conviction, because if you do, then if the defendant was 5 hours away in New York and had a job that he couldn't get out of, or lived close by but couldn't get out until 5 hours later, so delayed the treatment of the dog because he or she couldn't get out of work on time.
I agree with you. I think there is testimony that would have made the Commonwealth's case on this particular issue stronger. I do think that the issue here is the inference that we're able to make because of the passage of time. This isn't a case where the dog was walking with a limp. This is a case where they said, we think our dog ingested cocaine. What should we do? That's, human or animal. We know the consequences of an overdose. They are terrible. I think that the knowledge of the potential consequences are there. And at a certain point, the delay in seeking any kind of care does turn into intentionality.
So
Can you
look,
attribute- I'm sorry.
but I'd just say that the facts are just slightly different. How the factor of causing, whether the dog ran to the neighbor and ate poison or the dog ingested, in essence, poison in the home. The defendant's at work and he works at Stop and Shop. His shift doesn't get out until 4 o'clock. It's 9 o'clock in the morning now. Best he can do is bring the dog to the vet when he gets out of work and he brings him. That's animal cruelty?
I would say that the difference in those circumstances is the
Is
fact.
that one animal cruelty?
I would say is a closer case.
It is?
I
We're
would-
going to criminalize people who go to work and can't get out and then take their dog to the vet as soon as they get out of work because they're going to get fired and lose their job?
Not criminalize it necessarily, but I do think that the external constraints that are placed there do change what the defendant is able to do in those circumstances.
What if he can't afford it? What if he can't afford it? We're going to criminalize behavior of people who can't afford $5,000 or it takes them 5 hours to come up with some money. We're going to criminalize that type of behavior.
There was testimony from the various persons associated with the emergency hospital that had the dog been brought in earlier, the prices quoted probably would have been different because there would have been less to do.
Bad decision not bringing the dog in. We're talking about criminal behavior.
And
Can't afford to take your dog to the vet. We're gonna punish people with a conviction for animal cruelty.
I think too there's an element, oh, I'm sorry.
Go ahead, no, is that?
I think too there's an element that does come into this in the fact that the dog, and I have encountered dogs in my lifetime that have gotten into places they are not supposed to be, but the fact that the dog had access to and was able to ingest this cocaine and no steps were taken. It's not that they attempted to induce vomiting at home. It's not that,
Hold on. Do I hear you suggesting that because the dog got into the cocaine that contributed to the animal cruelty? Is that what I heard you just say?
Obviously getting into the cocaine is what prompted the animal cruelty because had there not been
I understand, but the act of getting into the substance, is that part and parcel of the animal cruelty?
I think it's something that the jury could have considered.
What do you attribute the delay to?
I could not speak to what was going through the defendant's mind, Your Honor. I know that I believe that at a certain point it did translate into just a lack of care.
Why do you think they called the vet?
Given that they took no steps, I can only assume that they were initially seeking guidance, but as the day went on, as the conditions deteriorated, as the advice to bring this dog in did not change, at a certain point, the calls to the vet become, I don't want to say performative, but they don't have as much meaning. At a certain point, you know that this dog needs care. And at a certain point, you know that not seeking care is going to make this condition, it's going to compound it and make it much worse.
So is that the point that they brought the dog in and paid?
It's, I don't know. I don't know enough about the deterioration to say that this is the point. But I do think the fact that, 9 a.m. is when the first call to the vet is made, 4 p.m. is when the decision to bring the dog to the vet is made. As Your Honor pointed out, that's a work day. There was a lot of time in there to make that decision based on any number of factors and any number of changes that took place in that intervening time.
But what I'm missing, where's the evidence the defendant intended for the dog to unnecessarily suffer? Where is that evidence?
I think my argument would be that that is inferential. At a certain point, you're watching this dog deteriorate and taking no action. And again, they took no action even on their own part at home. You know, there was no evidence of care that was taken there. At a certain point, it's the lack of action and the indifference to the deterioration that allows, I would say, an inference of intent.
Was it just one call to the vet?
I believe it was a total of 4 calls. I'm not sure off the top of my head, but I believe it was multiple calls.
Is there any other context in the criminal law where prolonged neglect turns into intent to harm?
I know that the case law does specifically contemplate it. I believe, I want to say, so there's not a lot of case law on animal cruelty. I believe it's Lufkin.
In any context, I'm just, you know, you're obviously trying to make this. That's your argument, and it may be. I'm just wondering, is there any support for that in any other context?
I believe it's Lufkin, which is 89 Mass 579 and is in 1863.
1861, right.
Where they do say that they use the phrase, the agony inflicted by inattention.
Can I just go back to but it's a separate part of the statute. When we're talking about knowingly and willfully authorizing or permitting, you agree with me that there is no duty to treat in Massachusetts?
I agree.
And you agree with me that the basis of this count is failure to expeditiously treat. So if you don't have a duty to treat a dog, how can you be found criminally responsible for delaying the decision to take the dog to the vet? I'm stuck there.
As I mentioned, though, there were no steps taken at home.
No, but if you don't have a duty, there's no duty in Massachusetts to get veterinary care for your dog.
That is fair, but I think...
How can then you be criminally responsible, convicted of being too late for something that you don't have a duty?
I can't speak to the legislature's thought process in enacting the statutory scheme. My argument would be at a certain point, it converts to a responsibility to take action in order to avoid just such a scenario.
So I recognize you're in a tough spot. But let me ask you this question. They called 4 times.
Yes.
To see, hey, if we wait longer, it's going to really hurt the dog, so we're going to wait longer. Why call 4 times if you're intentionally trying to hurt the dog?
Maybe hoping for a different answer. At a certain point, though, as I said, you know, whatever substance, even if the dog got into a huge amount of chocolate, it's poisonous for dogs, you know that that's something that needs to be addressed. Otherwise, the dog is going to suffer, deteriorate, and possibly die. Any number of phone calls isn't going to change sort of that circumstance.
What if they didn't call? So your dog gets into chocolate. So we're not even talking the crime. And I don't have any money. And you hope that this dog is going to live, and it doesn't. Are you charged with animal cruelty there?
I think, as with all crimes, I think it can be a very fact-based scenario. And I do think, you know, one of the factors here that I didn't particularly dwell on in my brief, but I do think is worth considering, is the fact that, you know, there's no reported call to poison control. There's no reported call to...
No, but can you be charged with animal cruelty? I get up and my dog ate the chocolate bar, and I got to go to work because I'm going to be in trouble if I don't get to work. And I come back at the end of the day, and the dog died. Is that animal cruelty?
Like I said, I think it's a...
If it isn't, then we're going to call it animal cruelty when I actually do go into the vet with my dog.
So I do think it is fact-specific. You know, there is not a lot of guidance here as to what circumstances. A lot of the cases that we have, it's very obvious when it's animal cruelty. I believe there's one older case where a dog is literally bounced off of a porch and dies. That's a no-brainer.
But that's the proactive steps of thou shalt not, as Justice Gaziano.
Right. But in this circumstance, I do think that, you know, having to go to work, having to deal with other responsibilities, There is, I would say, you know, we do have some responsibility to, you know, the domestic animals in our lives as a society. And so while there is not an affirmative duty to seek care, I guess I would argue that, you know, in order for our animal cruelty statute to have sort of any meaning, there has to be at least some sort of affirmative duty to take action at some point. So then the question, I guess, in this particular case would become when, you know, as I argue, does the delay translate into willful intent to inflict harm on the animal as opposed to, you know, doing the best you can for an animal in circumstances.
I think we're going to have to leave it there.
I was going to say, I do see my time is up. I hope there are no other questions.
Thank you so much. Matter stands submitted. We're going to take a short recess.
All rise.
Thank you kindly. We have 2 matters remaining on our list. We will now turn to 23P 1154, Mark TAMMARO, I believe, versus Stephanie. I don't want to butcher her last name. How do you pronounce it?
Rosio.
Rosio. Okay. And your attorney, Walnicki.
I think it's still good morning, Your Honors. Thank you very much, and may it please the court. I'm Matthew Walnicki. With me on brief is Parker Williams, and Kenny and Sam's here on behalf of Ms. Rosio. What brings us before this court today is a defamation case. As the SJC commented in AL versus Helen Broad, defamation suits are considered disfavored. And here we have a case that infringes, that impedes on First Amendment rights. And it's not just First Amendment rights of free speech, it's the First Amendment right to petition. Now, we also have a relationship between the 2 parties in this case that's interesting to note because it gives separate grounds for some of the arguments I'm going to make, but they should be looked at in context of the overall petitioning activity. Those 2 arguments are, number 1, we have a plaintiff here who is acting as a volunteer on behalf of a citizens group, a nonprofit organization. She's entitled to immunity under both the Volunteer Protection Act under federal law, as well as 85W, which is the Massachusetts version of that.
What is she doing? I'm sorry.
Ms. Rosio, and in the capacity she sent the email as the trial evidence and the other evidence pre-trial established, is she is the head of a nonprofit organization. It's an unincorporated organization, but still a nonprofit nonetheless. She's a volunteer for that organization, and she's sending out the email in her capacity.
To her girlfriend.
To her what?
To her friend.
Well, she's sending it to someone who is the wife of the superintendent of the Linfield Water Commission. She's actually asking in that email that it be forwarded on to possibly remedy the situation with her concerns. So she's...
Why not just send it directly to him at his office or wherever he, in his capacity as whatever he is?
For her, this was the direct conduit, something that she could send off quickly. I'd have to look back at the record. I don't have the answer right now whether she didn't have his email address. I believe that was the case. This was her easiest path to get forward, and the context is important. She's getting an email from another member of this organization noticing that there's 5 trucks on the property. She's quickly sending this off, and that's going to be a point I'd like to raise about it's a petitioning activity. Sometimes petitioning activity isn't something you have time to sit back and reflect on necessarily. You have to move quick. You have to petition quick. But she is doing so in her capacity as the head of a nonprofit. She's a volunteer. She's entitled toward immunity. That's the Lynch case that we cite in our reply brief. That was actually a Wage Act case where statutory violations were involved.
Well, that wasn't raised in the trial court, that immunity, right?
I was raised pre-trial. It was an affirmative defense. I believe they got into the evidence to support it. It wasn't a focus of the trial, but immunity is something that brings up standing in subject matter jurisdiction. I could rattle off a number of cases, I'm sure you don't want to hear them right now, that say that subject matter jurisdiction can be raised at any time.
Familiar with those cases. I mean, there's a lot to cover here, so I guess...
I'll move on then.
Okay. Mm-hmm.
But I raised that at the outset because it's important to consider her position and the position of the plaintiff, Mr. TAMMARO, as what we contend he is a limited public figure, because that gives context to the petitioning activity.
So tell me about that, and I think it's a very important issue. Is your position that anyone who is an active housing developer is a limited purpose public figure, or are there circumstances here that made Mr. TAMMARO a limited purpose public figure?
I certainly think that if there's not a bright line standard, the circumstances here justified him being a limited public figure here.
And why is that? Just give me the top reasons.
A limited public figure, you don't just look at who the person is. You don't just put someone in the box, I would say, because they have a title over their head. It's who they are, what they do, what the circumstances are here. And I believe the circumstances are here, even though there's some argument that he didn't interject himself in this public controversy, I would say he did interject himself in the public controversy by seeking permission to do a subdivision, once the issue of potential contamination was raised the first time, this was something that was very public. And we have to keep in mind that this project is going on in the Apple Hill neighborhood. They have an existing Apple Hill neighborhood group of which Ms. Rosio is the leader, but drinking water was something that was very important to this group and very important in the town. There had been a history of, whether you call it pollution because it's dirt or chemicals or something, we'll get back to the email in a minute, but there were concerns about the water supply.
Sure, and so I guess my question is, given that context, there's general concern about environmental concerns, drinking water concerns in the neighborhood, and there's a housing development that's planned, and there are, I guess from the record, Mr. TAMMARO testified there was 4 or 5 Conservation Commission meetings.
Correct.
And there were 4 or 5 planning meetings, and those were all really well attended. Is that enough to make him a limited purpose public figure?
I would say so here, and especially too because of the actions he took in connection with those meetings and moving the project forward. I believe he testified at trial, or at least submitted evidence before trial in the anti-SLAPP context, but I believe the evidence is that he was trying to alleviate the concerns of the group. And I think that's important to keep in mind too. It's not just one person making an accusation against someone and it goes away. This was a robust discussion that was going on.
And I think his argument as well, or one of his arguments, I don't want to speak for him, but it's sort of like, I'm just trying to build my houses here. And the fact that there's all this controversy gymmed up in the community about that, that's not my fault. I didn't interject myself into that. I'm just responding to the controversy that exists. Does that make a difference? Does he have to do something actively to sort of interject himself into the controversy to become a public figure? Or is it enough that the controversy exists irrespective of what he's done?
I think it's enough that this controversy existed, but I also think that building multiple houses, doing a project, going through this process is a little bit different than, let's say I'm going to put an addition onto my house. I'm a private person, going to have a contractor put a deck on my property. That's a different scenario. That's a simple zoning or planning board something. This is a controversy that was very public for a good amount of time, involving a neighborhood group on the other side, not just one neighbor arguing with another neighbor over a fence. It's something a little bit more than what I think Mr. TAMMARO would like this to be. And he was a developer, and he's doing a development in an area where there is concerns about development, more specifically water, and then that water is the issue. When you tie everything together, even if there's not a bright line standard going on a title, the circumstances here make him a limited public figure. And I think,
and if that's true, then that means that a malice standard applies, that requires reversal because
correct.
Ms. Rauseo's statements were assessed under a negligence standard. Let's assume for the moment that there wasn't a malice standard; it was just negligence. Your argument seems to be there's still a higher standard that should have been applied because her sending the email was petitioning conduct.
Correct.
And there doesn't seem to be a lot of law out there about protections that apply to petitioning conduct when there isn't the sort of malice standard apply under the speech clause of the First Amendment. So you can tell me what you think, and I think there's a serious problem with what trial counsel did here by requesting the instruction that you're actually objecting to now. But sort of just setting that aside for the moment, what do you think is the right standard if it's just a question of protected petitioning conduct under the petition clause?
Well, I think I do have to go back to what trial counsel did in order to go forward. I think we do have to take that step back going forward because we have to keep in mind that petitioning activity was always part of this case. Petitioning activity was raised in the anti-SLAPP motion ahead of time, and unfortunately, it was addressed under the wrong standard then. It was addressed under the prior follow-ups on Duracraft where you had the two-path approach. Bristol Asphalt came out since the trial court ruled here, and because the trial court just has an endorsement, we really don't know which path she chose to go down. That could have influenced everything else. But if we get to the trial stage, there's some suggestion in my opponent's brief that there's never been a case where petitioning activity was a defense in a defamation case. Well, that's simply not the case. I mean, we saw the Hannah case. Your Honor, Judge Toone, you were on that panel that decided it, and I think that just bolsters what's going on with the Bristol Asphalt decision. And Bristol Asphalt reinforces Duracraft, which says once you establish petitioning activity, something that really isn't in dispute here, that there was petitioning activity, The burden flips for the opponent to establish that the record is devoid. And it's a de novo review. It's a de novo review on the record evidence. That's what Bristol Asphalt says. So this court could look at the trial record. This court could even go back and look at the motion, the anti-SLAPP motion record, because it's on the documentary evidence.
Right, but the anti-SLAPP motion wasn't, there's a right of interlocutory appeal for anti-SLAPP, and that wasn't taken advantage of here, and so that's not really before us now, but your argument is that standard in the anti-SLAPP statute should have carried over to the substantive liability standard at trial?
Correct, but I would challenge that a little bit, Your Honor, respectfully. I would say that even though there's a right to an interlocutory appeal, it's not an obligation to an interlocutory appeal, especially in this circumstance where the incorrect standard was used below and it was clarified in Bristol Asphalt. I think that would give us a chance, would give Your Honors a chance to take a look at the record if it wanted to, but I think that door is still very wide open for us to make that argument. But as to the standard, the Bristol Asphalt was important because it says that you're not the judge, whether it's a trial judge or appellate court judge, not supposed to give credibility assessments here. As long as there's, the only way that the petitioning activity does not get applied, that standard does not get applied, would be if the opponent proves that the record is devoid of any reasonable basis for facts. So if you look at the email that's in question, and again, it starts out, the email chain starts out with Ms. Rosio getting the email, talking about the trucks on the property. She's forwarding it very quickly off through a process that she believes is petitioning. The recipient, the ultimate recipient, Mr. Sina, who's the superintendent of the Linfield Water, he actually responds back saying, I hear your potential concerns. I'm paraphrasing. I hear your potential concerns. This might be more appropriate for other people, the town engineer, the water engineer. So I believe everyone involved in this communication recognized this was petitioning activity.
Can we interrupt for,
Sure.
can I interrupt for a moment? I understand and agree with much of what you're saying when it comes to Bristol Asphalt. When it comes to that, if the burden has been met, that this is petitioning activity, and the only way to, in essence, fight that back is by showing that it was sham petitioning. Am I reading this wrong? Didn't your client concede the fact that there was no basis to claim that there was contamination in the water?
I don't believe, and we may be mixing up what was happening in the clean water case that had been decided, but we were talking about what was going on here. There was plenty of evidence at trial about iron in the water. Dirty water was referenced. Whether you call, and that's the point we make, the term pollution, which is what she uses in her email, pollution doesn't have to mean you have PCBs in the water or something. It can be dirt. It can be any, in fact, the Clean Water Act defines it as dirt or fill or other things. So I do think that.
So what evidence, I'm sorry, I got to make.
And I do want to make sure I leave at least 1 minute to talk about damages because there's an important point on that.
But before we get to damages, what evidence was there that he was polluting the water fields? What evidence did she have, or was she in possession of? I mean, in the, I think it was the federal court case, he filed a motion for summary judgment. There was no opposition to it. Now we're here, and the statement is, can you stop TAMMARO from further polluting our drinking water field? So one, further polluting. What evidence was that he was polluting originally?
Well, you can read that the way we read that, which is further polluting. If the water is already polluted, it's not saying necessarily that Mr. TAMMARO is further polluting from his prior pollution. If the water is contaminated, and you're saying in a quick email, further polluting, making a bad situation worse. Any construction activity at a site could make activity worse. This is an initial, help me out here.
Yeah. And what, if anything, do we do with the animus that seems to be targeted at Mr. TAMMARO because he demolished a house that she was very friendly with the previous homeowner in order to build these. I mean, we're talking about a 3-acre land that building 2 residential houses. So I understand we're talking about development, but we're talking about a 3-acre piece of land to build 2 residential homes. But that being said, there seemed to be some animus because in the course of that, he had demolished one of the houses that she was friendly with the person who owned it initially, and she liked the house and seemed to be upset that that house got demolished. Does that fit into the equation at all?
I would say the animus would not fit in under the Bristol asphalt. Malice would come in if you get rid of Bristol asphalt and you start dealing with the the limited public figure. So it's sort of ironic that they want to bring malice in when it's helpful, but not have malice in otherwise.
Is that what lawyers do?
Yeah. Just very quickly on damages, I think it's important to note we make the causation arguments throughout our paper, both under a traditional argument. Even in per se cases, you need causation. I read Bristol asphalt as reminding this court that when you have petitioning activity, you have to show causation of actual harm. So whether or not defamation has one damages standard, we can't overlook the fact that this is not merely a defamation case, but it's a petitioning activity case. So you have to look at causation of actual harm, even if you were to buy the argument that per se defamation doesn't have causation, which I think per se liability does not mean you get rid of causation. Per se negligence, you get a blindfolded truck driver, they don't hit the car, then there's no injury.
A couple things on that. So one, there was on the jury slip a finding of economic damages, right? I think it was 50,000, right? Are you saying that, are you challenging the theory that Mr. TAMMARO, this was defamation per se, that was a theory because I guess it affects business reputation? Was that an invalid theory to be allowed?
I personally don't, as I read the document, I don't believe that defamation per se should have been allowed, but.
Why not?
Because I don't see it fitting into one of those 5 categories, and I feel like I'm rushing, so I apologize, but yeah. I don't feel it fits into a defamation per se bucket here. But even if there was defamation per se on the reputation, I think you still need causation. If you're going to get damages for economic harm, I think you still need causation. Those are traditional defamation theories. I think even if we're dealing with just defamation, you still need causation of A to B. When you get to petitioning activity, you definitely need, per the Bristol asphalt case, a connection between A and actual damages. And I would contend, even if you're allowed emotional distress damages under defamation per se, when it's defamation per se with added the petitioning activity, you now actually have to show actual damages, not just some type of emotional harm.
I see that's your time.
Thank you, Your Honors. And thank you for letting me go a little bit over.
Attorney Gallagher.
Good morning, Your Honors. May it please the Court, my name is James Gallagher. I'm here on behalf of Marco TAMMARO, the appellee in this case. The jury verdict and the judgment of the Superior Court should be affirmed because there were no errors, as the justices have already examined with the appellant here. Mr. TAMMARO is a private figure, always has been a private figure. Nothing that was submitted during the trial changes that fact.
Well, he testified that he himself testified there would be 10 meetings about his project development, and there was like 40, 50 people at each meeting. There was clearly a lot of concern in the community. Now, you may dispute whether that concern was justified or not, but there's a lot of concern about this development. Why isn't that enough to give rise to him as being at least a limited purpose public figure? He's doing this, he's in the middle of this public controversy.
Well, I would take umbrage at least to accept the construct that it is a public controversy. I would submit that every developer, even a homeowner, if they need any work done at their home, they have to go through the public process of perhaps submitting to the Planning Board or the Zoning Board of Appeals. If you're within a certain amount of distance from a water body, you have to go through the Conservation Commission to meet all your public requirements.
Yeah, but most of those meetings don't have like 50 people showing up at each one, right?
That regulatory scheme alone does not convert this to a public controversy. Now, Ms. Rauseo has been familiar with Mr. TAMMARO since he purchased this property now almost a decade ago. And whether there was, as the court has already acknowledged, there was some interest, perhaps because of Mr. TAMMARO's decision to develop it, to put 2 families. Originally, he was just going to put his own home there. But he did demolish the house that was there so he could develop it and build 2 single-family homes. But again, he himself is going through the regulatory process. He has not done anything, and I would submit there's no record evidence to the contrary, where he has done anything affirmatively to create a public controversy.
I guess that gets to the question: is that required? Does the plaintiff actually have to inject himself into to qualify as a public figure, or can it be the public controversy be placed upon him?
Well, he can't be dragged along, and the case law is pretty clear that you can't simply be dragged into the public controversy by actions of someone else and then be forced into that limited purpose public figure or even a limited purpose public figure role. So I would suggest that's exactly what was happening here. As soon as the house was demolished, the whole tenor of all this development changed, and more Mr. TAMMARO was sucked into this. There is only one piece of evidence that either side has acknowledged. It is an article that Mr. TAMMARO published in a newspaper defending himself. That was it. He, besides going through the required regulatory process to get to certain approvals, that is not sufficient. And I don't believe there's any case law to show that forcing either a homeowner or developer to comply with regulatory requirements is that affirmative step.
I guess there was this pre-existing concern in the community about the quality of the drinking water, environmental concerns. This was a long-standing issue that it goes beyond Mr. TAMMARO's role. And so he by proposing a development in this area, he's entering that area of public controversy. So it's really hard to sort of say, well, he wasn't a limited purpose public figure when you're building a development in an area where there's already kind of pre-existing concern about environmental concerns, drinking water.
Well, Your Honor, I think that there's a general concern throughout all of Linfield, and the articles that Ms. Rauseo submitted in the federal court case actually led the federal court to dismiss a lot of her claims because the town and the town public officials at that point, and this is pre-Mr. TAMMARO doing anything, acknowledged that this was a Linfield-wide issue that really resulted from the presence of manganese, and I forget the other particle that was in the water, that led to the discoloration. And I would also point, for example, there's a map that trial counsel for Ms. Rauseo tried to submit. It's a map of the Beaver Dam Brook that talks about there's a black and white at the appendix version 1, page 135. There's also a color version in the record appendix, section 4, page 29. And that is a colored map that talks about all the water bodies in Linfield, in the greater Linfield area, and the water issues that were going on. So I don't think it's fair to say that Mr. TAMMARO, just by purchasing his property, is injecting himself in. That seems to be a stretch too far, and I think that's...
Can I ask about the federal litigation? Because this really played a big role in this case.
Yes, Your Honor.
And I understand that Mr. TAMMARO probably is very frustrated by the sequence of events that happened, because the federal litigation plays out for 3 years and ultimately is dismissed. But it's not dismissed on substantive grounds, right? The Clean Water Act claims are dismissed because lack of standing and lack of the failure to sue notice. And then there's summary judgment entered on the, centered on the Clean Water Act, right? But there's 2 grounds there. One is there are no U.S. waters, right? And that's a jurisdictional requirement. And then the second ground is, the substantive defense of the testing. Judge Gordon enters an order. There's no opposition, enters an order without sort of commenting on the basis for granting summary judgment. But in federal court, you normally look at the jurisdictional issue first, right? So there's no finding that there wasn't pollution here. There was just dismissal of the case based on the lack of U.S. waters in the area. But it seems like this federal litigation is kind of used in a lot of different ways against Ms. Rosio in the court. She's not allowed to present any evidence about prior pollution, even though that's relevant to her defense of what the email that she sent. And I think in your closing argument, you sort of say, here's a man who just got, the federal court found he wasn't a polluter, and now she's saying that he is, right? Which isn't really consistent with the record. So I'm just trying to get your understanding of what did the federal litigation establish, and really should that have influenced how the evidence sort of came in at this trial?
Well, Your Honor, I believe the first part in the motion to dismiss for Ms. Rauseo filed the case along with her Apple Hill neighborhood group. At the motion to dismiss phase, there was a Safe Drinking Water Act claim that was dismissed,
right.
and the Apple Hill group was dismissed as a party. Those were primarily on causation and jurisdictional issues.
Yes.
Then it went forward on the Clean Water Act claim alone against Mr. TAMMARO. There was extensive discovery. Both parties were deposed. Documents were exchanged. And my client went through the process of hiring an expert, which he had already done with the town because of these other issues. The Army Corps of Engineers was also a defendant. They had tested the ground. But Mr. TAMMARO, just to make sure that we were going to be successful to prove what he already knew, hired an expert. We went out and dug extensively on the property, multiple test pits, at up to depths of 27 feet to establish conclusively that there was no pollution, not only in the fill that was bringing in, that there was none of the dirt on that 3-acre parcel was polluted, and that even taking into account the water that was leaving the property, that assessing the cleanliness of that water, that there was no pollutants leaving the parcel. And that ties directly to her leaching. The pollution is leaching away from his property into our drinking water. It just
Well,
not
she
the
said,
case.
she said, stop TAMMARO from further polluting, right? Which doesn't, and she testified at trial, she wasn't saying that TAMMARO had previously polluted. She said that the area was polluted, and she didn't want him to further pollute, right? Which
Your
is
Honor,
a big difference from making a direct accusation that he had polluted in the past.
and I understand that, and I take their argument. I would say that that is actually not, I mean, that is creating a whole new argument of whole cloth. And I would point the court to her answer in this case. And I will, excuse me, pardon me, but it appears, it is at the Record Appendix 1, page 81. It is in her response to paragraph 24. And she writes, the defendant emphatically denies that she has no evidence for her claims. She further asserts that Mr. TAMMARO polluted his property. There is not one point in the 10 years that I have been involved with this that she has ever taken the stance that she now advances, that she was just saying, oh, the water was already polluted. I wasn't really referring to Mr. TAMMARO. I was worried that something else might happen. That every single time that she has come to court, she has accused Mr. TAMMARO of polluting.
But isn't that her right to do so? I mean, I understand at some point in time that a defamation suit may come, but what she was doing, I'm in a different place right now still, which is, how is this not petitioning activity, right? Whether I'm in a nonprofit, incorporated or not, I've got concerns that there's some unsafe drinking water, and I write to someone and say, as a private citizen, you got to do something, stop further polluting. How is that not petitioning activity?
Your Honor, I think first, as Justice Desmond pointed out the first time, Ms. RAUSEO testified at trial that she sent this to Ms. Skenna as her friend, really in a private context, hoping that she would pass on to her husband to sort of leverage her husband to do something. And I don't think in that, being that that's the admission of Ms. RAUSEO of why she sent the email and why she sent it to her, that is actually a petitioning activity, and I don't think it meets the definition of 59H, the statute. The only one, and if you look at it, I think the only one that there's 5 listed activities that could suffice as petition activity. I think there's only one that arguably it could fit under, is that any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body or any other governmental proceeding.
But she sends the email to her friend and says, oh, can you share this with your husband who's on the water district, right? I mean, it's like a little indirect, but clearly, you know, it's an attempt to sort of influence, you know, to bring a concern to government officials or government-esque officials. Right?
Your Honor, I think respectfully, if we get down to that level of granularity, I mean, the amount of people that are contacting friends to contact friends to contact friends, I don't know that courts should be responsible for that, to engage that level of detail. I'm sorry, Your Honor.
If you just look at the cases that someone's sending an email to her friend, then how can you possibly make a case for damages here, right? I mean, that's what if the offending communication is sending an email to your friend, and then you go and get sued and you have to pay $150,000 or whatever the ultimate damages award is, that doesn't make a lot of sense either. It's either one or the other, right? And it seems like the theory was she sent this email, it got to the water district, he forwarded it to the town engineer, and therefore he shut down his operation, which I don't quite understand too, since he had all these testing documents that he could just have shared with people in the town. So I guess it has to be one or the other, right? Either it was, this email was meant to influence government action or it wasn't, but it doesn't seem you can have it both ways in terms of establishing damage but saying it wasn't petitioning conduct.
Well, even if it was, there is no reasonable basis in fact or law that Ms. Rosio had at the time she made that statement. And she testified to that, which the court brought up earlier. I mean, she specifically admitted in her testimony, this appears at Record Appendix 2, page 497. Did you have any evidence or report anything that pollutants were leaching from Mr. TAMMARO's property into neighboring properties? From these trucks, she answers. Question, yes. Her answer, not from these trucks, no. So
That's if you read the email as saying, as an accusation that TAMMARO is polluting, right? But
Yes,
it's
Your Honor.
also, the email is also talking about he's not properly installing the silt fences, right? And there was evidence, there was a photo that Ms. Rosio wanted to introduce showing improperly installed silt fences, and she wanted, I guess, have her son testify, who's an engineer, about that, and the judge said, no, we're not going to relitigate these issues, we're not going to let you prove that. So it seems like there's a lot going on with this email, and nevertheless, Rosio was not able to kind of like substantiate her concerns and show why there was an objective basis for them.
Well, I would suggest, Your Honor, that I don't think she ever had one. I mean, she admitted she was in Vermont. She had just received, I mean, earlier that spring, we had gone through the summary judgment issues. She knew that this land was clean.
But even if she's wrong, right? So if I have a concern, I don't know anything about water, but I think that it looks a little dirty, or someone tells me, and I write to someone and say, hey, could you check this out, and I want to put you on notice.
She had done that, Your Honor. And the question becomes, how many times can you run your head into the wall and get the answer that he's not a polluter, and you still go forward knowing all of that he's not polluting, his land is clean, and still make these accusations? And it does forward from Ms. Skenna to her husband through the town. And so there is an impact. And so I would just want to forward to damages. First, I would like to apologize. There is a misstatement in our brief about what we asked for at the trial. We did ask, the total was $575,000, but it was $400,000 in lost profits. There was $100,000 in emotional distress and $75,000 in carrying costs. So the number is the same, and I apologize for that oversight in our brief. It appears at page 50. But I wanted to point it out to the court so you're aware of it. And that leads us to the damages, because there is $50,000 award for emotional distress, because I think there is sufficient record evidence about the impact this had on Mr. TAMMARO personally. And there's also impact that Mr. TAMMARO testified about, the financial impact to him, both his business and the carrying cost, because he could not move on with this parcel. And I realize my time.
How does an email sent like this shut down someone's operations, particularly since he had already accumulated all this testing data? That's what I don't understand is what happened here is sort of, the federal court litigation, he does all this testing, which seems very helpful. Why doesn't he just share that testing with the town officials and sort of alleviate this concern raised by a citizen? Why does he instead sort of shut down the operation and claim emotional? It just doesn't make any sense to me.
Well, Your Honor, I don't know that was covered extensively. I mean, and I don't want to get into things that are not before the court or wasn't before the court, but I think that that information was shared. I mean, everyone knew that Mr. TAMMARO had succeeded at the federal court litigation based on the testing. And as I mentioned before, the Army Corps of Engineers had tested it, and the town of Linfield had hired their own independent third party, and that's in the record. They all had tested it multiple times, and they all knew it was clean.
So why does this one person's email inflict so much damage?
Your Honor, you'd have to ask the town official, the engineer who showed up and shut it down that day. And I mean, he was not a witness at trial, but that's what happened.
He shut the project down?
He was shut down for a period of time until.
Is that in the record that it was shut down?
Mr. TAMMARO, I could get the record, but he testified that the town engineer showed up that day at 4 o'clock. and asked him to
Asked
stop.
questions, but did he shut down the development?
I believe that there was a period of time that it was shut down. I don't know off the top of my head where that is, but I could submit something if the court would like it. But I believe that there was something. Mr. TAMMARO testified about the town engineer appearing that day after the email was sent. And then, so if you look at the Donovan case, for example, the increased scrutiny from a government official, I mean, that is sufficient to show the causation and the impact of the statement. Whether the court looks at it as small or large, there's impact, and Mr. TAMMARO has established that impact.
I guess it's just the fundamental problem is there's a little rough and tumble in being a housing developer, right? And he goes through 3 years of federal court litigation and succeeds, and then an email by someone to her friend, to the wife of a town official, is suddenly enough to sort of stop all progress on a development. That's the gap there that I don't quite understand. I think it's relevant to the damages issue that they're raising.
Well, and I think also it's the first time that the water department in and of itself is involved. If you look at the whole history, Mr. TAMMARO started at the planning board and the conservation commission. He had been fully permitted by the town with the town engineer. The water department's not really involved in that type of assessment. And then there's the federal court litigation. Again, the water department in and of itself is not involved. And then this is the first time where the water department is now reaching over to the planning department to say, hey, I want to look further into this.
They said, well, it's really not something in our control. We're going to refer this to the town engineer, right? And the town engineer goes from there.
Yes, Your Honor.
Okay.
We're going to have to leave it there.
Thank you, Your Honor.
Nice job, both sides. Matter stands submitted. And our final matter for the morning is 24P0025, David Minnick and another versus the town of Chatham. And we'll hear first from Attorney Riley.
Good afternoon, Your Honors. I believe I'm the first one that can now officially say that, as it's slightly past 12. Thank you so much for having me here today. I am Attorney Anthony Panabianco on behalf of the plaintiff and appellant, David Minnick and Michelle Cross. The three questions before the court today are whether or not the court erred in finding the defendant did not enter or cause to enter upon the plaintiff's property. Second question is whether or not the interference with the plaintiff's use and enjoyment of their own property was substantial or unreasonable. And the third question was whether or not the court erred in finding that the water intrusion must be intentional, reckless, or negligent to constitute a nuisance. We answer to all of those questions that it should be yes.
Can we start with the trespass? Your theory of the intentional trespass is the water that came from the eastwards down into the catch basin and then into your client's property is the intentional trespass. Is that right?
Yes, and I pause you in the language as for whether or not it is required to be intentional. But if we look at if we go back to the judgment of September 8th in our record, the court did find in that the defendant failed to control the flow of surface waters from its property.
But what he didn't find is that there was an intentional trespass. So separate and apart from in cases in which you have a property and you create either an artificial device or the water directly lands into an abutter's land. This is not this case. This is your client bought in lowland country. There was a highway that water was coming off of. There were other properties. And then the last straw is the higher property all the water from all those different places are coming into one catch basin, correct?
We disagree with that contention, Your Honor, and if I'll be...
So is your claim of, because I don't understand your claim of intentional trespass. Nuisance, I understand, but the intentional trespass, where is there evidence that water from eastwards intentionally entered your client's property?
I think linguistically we might be getting caught up on the word intentional. If we look to the case of United Electric, the quotation therein is that there is a trespass where a landowner who sets in motion a force which in the usual course of events will damage the land of another is liable for intentional trespass. It is not the intent to harm that might be what you're referring to or you're thinking of. It is, are the intentional actions that you are...
The action of the trespass. So how is it, and when we look at this deferential standard, when your client testified that before Eastward even bought the property, there was water in his basement?
Your Honor, if you look at page 99 of that record testimony, my client's testimony, you'll note therein that this is a complete red herring from my brother. My client testified on that page that the prior water, was a cup compared to 40 gallons of what they had during the October 22 event, which is post the development of their properties. But the more important part of that is that it's on an entirely opposite side of the property. They're unrelated whatsoever. If you look at, I believe it's page 32 of my brother's appendix that shows the diagram of my client's property, you can see wherein on the left-hand side of that diagram, depending on how you're looking at it, it only has one home on it, and that's my client's property on the right-hand side. On the left-hand side, split between Whiteley's Way are the two properties of the Eastham properties. That water of where there was less than a cup of water in 2021 prior to the development is on the far side, across the road, and through the entire backyard, then the home, and on the other side of the property. It is unrelated whatsoever to the eastward properties or the catch basin. It is a natural event that there was a large storm and there's some water on the other side of the property. Here, what we're here before and we're at trial about was the intrusion of surface water runoff from the eastward properties down across Whiteley's Way, overwhelming the catch basin, not once, but multiple times since the development of it, onto my client's property. You'll note from the record that we have before you is the language not of my client in this instance, is the language of both their engineer and their principal, Bill Marsh. The defendants acknowledge in their own words that their topography was significantly graded and severe eastward properties. They admitted that the road drainage system was woefully inadequate. That's the language that the defendant used to describe the property before they built upon it. And when they built upon it, they didn't do any due diligence, as we note in our property or in our brief, pages 22 to 23 record appendix, 147, 148, and 153. That's the testimony of their engineer, Mr. Clark, who acknowledges that their due diligence was inadequate, essentially therein, that they didn't do the requisite needs to determine the entire catch basin, the impact that it may have on other properties. For your original question, what is the intent? Their intent was to build, and the lack of due diligence, the intent to make it severe, the knowledge that the catch basin was woefully inadequate, that rises to the level of what the United Electric case stands for. Did they set in motion a force which in the usual course of events damaged the land of another? That's the intentional trespass as holding under United Electric, and that's precisely what happened in this case. They set it in motion. The prior rain event of a cup has zero to do with this matter, these properties. It's a red herring, absolutely.
Speaking of red herring, this issue of the error of law. So I'm just having some difficulty when I read the entire record because unfortunately we don't have your request for a special verdict form, correct?
Correct.
Okay. And so Did you ask for a different standard in your special verdict form?
The verdict form that was used, I believe, was discussed with the court, and there were some nominal objections to it. But the form in and of itself is not the question before us today, and the questions that are before us now.
So my question is how was it preserved? Because if you had asked so I read the transcript in the beginning, there was a little bit of a slight quarreling about whether or not there would be one special verdict form proposed by counsel. And it never seemed to be, in reading the whole transcript, entirely resolved. But what I also didn't see is anywhere in which you preserved this issue, where you raised the issue of this standard that was properly before the Superior Court judge. I just don't see it.
And I don't, the argument at the onset of the case of arguing about whether or not there was how the jury or the verdict slip form would be discussed would preserve it, but two, it's unnecessary to do so because that's not the scope of the argument here today as to the content of or the questions of that verdict form.
I'm confused. Did you agree with this proposed verdict form? Was this a joint submission?
Well, I don't recall I know that we had discussions with the court and had submitted different proposals beforehand, and by the time we got to court, I don't recall as I sit here at the moment, but I don't think that that's a requirement for this court to consider what is before it. We're not making an argument and haven't made an argument that the verdict form in and of itself was improper. It is that the verdict form as determined, or the provided answers on the verdict form do not correlate either to the facts and is an error of law to determine in this instance that there was a failure to control the flow of surface waters from the properties, and then to say that there was not trespass.
But on the error of law, you claim that the judge used the wrong standard.
Yes.
Okay, and so my question to you is, did you ever raise this issue before the judge by way of a request in a special verdict, by way of argument? Was it ever before the judge in the Superior Court prior to him deliberating and filling out that special verdict form?
Yes, we do believe that it was raised.
Tell me where, because I missed it. I've been looking for it and I missed it. Tell me where.
I believe it was at the onset of the trial when we were...
Very vaguely at the onset of trial, you discussed that you're both not exactly in agreement with the special verdict form, but there is absolutely zero substance as to where you agree and where you disagree. And then the trial ends and there's, I don't see any discussion about standards or applicable law.
And I don't think it is required to be so in that. We submitted...
How is it not waived?
Because, Your Honor, again, it was raised initially at the onset of the matter, and again, it is not the form of it or the question of it. I think you're being bogged down by that particular question, wherein
well, I'm not being bogged down. I'm reading what you say. You say the judge made an error of law in applying the wrong standard. How am I getting bogged down there?
That only relates to one of the three questions that we have.
That's the one I'm looking at right now.
I can appreciate that, but I only have 3 minutes left, so I do have two other concerns that I want to raise.
We do need to know. Oh, sorry, go ahead. I'm sorry. There's a question before you?
Yes.
I understand that you'd like to move on to some other things, but first answer the question, and then we can move on.
And I think I have, again, it was preserved at the onset of the case, and the secondarily issue of whether or not the verdict form was appropriate can still be questioned after the fact because it was preserved at the onset and it wasn't agreed upon. But two, the correlation of fact-finding is what we have a concern with, and also the error of law of determining in that instance is unreasonable to find that that they failed to make a control of of the surface water flow onto the property, but then make a finding that there wasn't trespass. The error of law that we refer to is that consideration of you're making a finding of fact that there was a failure on behalf of the defendants, but yet that doesn't constitute a trespass. The error of law that we discuss regarding trespass is that consideration of did they set in motion that force? The judge found that they did, but then doesn't find that there was a trespass when if someone sets in motion a force, they must then find trespass. It's the similar argument for nuisance, though less nuanced, I would say, as to the nuisance claim as to whether or not there was a reasonableness standard here. That's the standard that we both parties agree to that is necessary here, and the reasonableness of whether the actions of the defendants in building without doing the proper due diligence, knowing that there was concerns and woefully inadequate catch basin, whether or not that constitutes a reasonableness standard, and then onto the damages portion, whether or not there was reasonableness of the plaintiffs for how they have lived on their property out of fear, losing sleep, having to monitor at every rain event now that they've never had to do, the work that they've had to perform to mitigate the actions of the defendants, the costs that go into that, whether or not that's reasonable.
I understand. Just can I interrupt you?
No, I'm good, thank you.
All right, go ahead.
So to tie it all back to my original questions that I had before this court and the court asked about is whether or not the court erred in these findings. We say that they clearly erred in the findings because the facts only support one form of determination, one form of conclusion. And that initial conclusion that the court agreed with, that there was a failure on behalf of the defendants, should translate and does translate into findings for nuisance and trespass in favor of the plaintiffs. The second one is whether or not the court erred in its findings that water intrusion would need to be intentional negligence, it was preserved and is properly before this court and should be considered. But the error that we refer to significantly of the error of law in our papers is the acknowledgement in that form that there was a failure to maintain the property, but no, there was not trespass or nuisance. That's the error of law, that you cannot make a rational conclusion to have a failure to do so, but then no trespass or nuisance thereafter. That is the error of law of which we are concerned.
Let me ask you a question, just circling back for one moment with respect to what you characterized as a red herring about whether or not there had been an episode like this prior to his purchase of the property. And you say the answer to that was no, because the water previously had come in on a different part of the house versus where it was now coming in and was less water.
Yes.
But wasn't the question whether or not water was coming into the house as a result of overflow in the basin?
That's the question before the court. That was the question before the court.
And wasn't that the question before your client, who repeatedly said no? And I thought I heard you say, well, you know, he was saying that it wasn't quite the same, not no, it didn't happen before, no, it was on a different part of the house.
Yes, so that the 2021 water event had zero to do with the catch basin being overwhelmed. It was on the opposite side of the house that isn't really.
How did that water, what was the cause of that?
Standard rain, standard 3.5 inches of rain on a given day. He testified to that produced 1 cup of water. By contrast, there was 3.5 inches of rain on the October 22nd after the development, which created 40 gallons of water in the property. So you have the same rain amount, but 2 different scenarios, only due to the development upland by the eastward properties. So that, and in different parts of the property, different parts of the home. So I don't think they can be related or considered as a water event. As we talk about in our paper, we make clear that it's surface water runoff.
Got it. Thank you. and I apologize. I called you, attorney. Got my names confused, so you're not.
Good afternoon, Your Honor. May it please the Court, William F. Riley on behalf of Eastwood Companies. And if I could just make one comment about the September 21 rain event. Mr. Minnick's testimony did not differentiate that flooding event from the flooding events that occurred after Eastwood bought their property. He did say, well, it was only 1 cup of water, but the only way for the water to get there was to overflow the basin. And he did not say, oh, it didn't overflow the basin. There was no testimony regarding that at all. And with regard to the question the court had about the verdict form, we each submitted a verdict form to the court. And then the court subsequently returned the form that we had and said, do you have any objection to this? And neither one of us had an objection. So that's how we came to be using that form.
Can I ask you, is that on the record somewhere? That's just your memory. I'm not distrusting what you say. I just don't have it before me.
Well, I understand that, Judge, and you know, it was a one-day trial, you know, no written requests, and things were casual. I will suggest a little casual.
But there is some transcript somewhere that shows this, right?
I've not been able to find it, no.
Okay.
I mean,
it's important. It's important. Both sides, you know.
Yeah, no, I understand that, but that, you know.
We can only review what's preserved. Okay, go ahead.
There was certainly no objection to the form at the time it came out. In any event, so what we have is a water case where runoff goes in accordance with gravity from the high point on the property to the low point on the property. The Eastward became aware of the concerns of Mr. Minnick because Mr. Minnick reached out to town officials prior to Eastwood even beginning serious construction on the property. As a result of that, during the construction of the property, Eastwood worked to alleviate, to the extent that they could, runoff from their property. Initially, in October, prior to the October rain event, they retained a contractor who cleaned out the catch basin to make sure it was operating, you know, to the maximum ability.
I just want to interrupt. I think we're well aware of the facts of this. What is the evidence on the trespass that there was no intentional trespass? So, very deferential standard given the procedure that was used, right? Jury waived the findings of fact, special verdict form. So, evidence from whatever source that there was no intentional. Your brother says it was uncontroverted evidence that there was a trespass. What is the evidence of the absence of that?
Well, in the first place, my brother equates the United Electrical pumping grout into underground conduits with rainfall landing generally on a subdivision, in the subdivision lot. Mm-hmm. So in the case cited by my brother, they were pumping grout onto the property. In our case, it was rain falling from the sky, landing on the entire subdivision, not just our lot. And I think what we can show is a lack of intention. So the things that Eastward did when they were alerted to the concerns, they cleaned out the catch basin. They made sure that the leach pits into which the catch basins drain were functioning properly. They put dry wells so that the runoff from the roof went into dry wells rather than onto the lot or onto any of the hardened surfaces. Using the advice from their engineer, David Clark, they installed a trench drain at the base of the driveways, which came down to the road, and they put in a 4-inch trench drain. Clark said that's not sufficient, so they took out that 4-inch trench drain and put in an 18-inch trench drain.
So in your opinion, this evidence of Minnick saying there was prior flooding prior to Eastwood buying the property, where does that fit within the judge's analysis?
Well, we didn't, Mr. Minnick's acknowledgement that there'd been a flooding prior to Eastwood work came on redirect testimony, admitting to a failing of old age. I didn't have my hearing aids in, and I missed the answer to the question. I mean, I heard the question, but I missed the answer to the question, but I wasn't concerned about it because he'd already answered that question 6 times during the course of the day. So I just assumed he would say, oh, no, there wasn't any. And then I only learned about it when I actually read the transcript. So
where does that fit, though? How is that relevant to the judge's determination as to either trespass or nuisance? The fact that there was flooding before Eastwood came.
Well, I think the trespass is an intentional act. And we're really talking about gravity. It had nothing to do with what Eastwood Company was doing. Eastwood Company did what they could to reduce rainwater running off their property. The finding that the court made that they failed to control the water had to do with the fact that water was coming off the lawns. The testimony in the court is that 5,000 square feet of each lot, which constituted the roof, the driveways, and the sidewalks, was not contributing any rainwater to the roadway drainage system. So we significantly reduced the amount of area that the lot was contributing, rainwater in, but we did, they did not control runoff through the lawn areas. But it was greatly reduced from what had previously.
Right. I'm just trying to connect the dots with admission that flooding happened before Eastwood came, therefore, what on trespass, therefore, what on nuisance? Where does that factor in the calculus?
I guess I don't entirely understand the question, Your Honor.
You respond in your brief saying, despite 6 times saying it didn't happen before, Minnick says, hey, even before Eastwood came into purchasing this land, it flooded, and it flooded, the basin overflooded, and water came into my home, right?
Right.
Okay. So what is what I'm...
They tried to reduce the water flow, but instead, for some reason, it increased the water flow. So notwithstanding that they had...
I suppose so, Your Honor, but this is, the Tucker v. Bedoyan case. I mean, it's really a question of, was our use reasonable? And I think that's my brother's issue about an error of law, because the court also talked about, the fact that they weren't engaged, Eastwood wasn't engaged in ultra-hazardous activity but the court found that Eastwood's use of the property was reasonable. And Tucker says that if you change the flow of groundwater, rainwater, and it causes some harm, but in any event, the court finds that the use is reasonable, then a claim of nuisance shall not lie. That's DeSantis versus the Lynn Water and Sewer Commissioners. So that the Eastwood did everything. They just developed their property for a single-family house. They made sure that none of the impervious surfaces were contributing rainwater into the road drainage system. There was a property at the corner of the State Highway and Whiteley Way that had been there for many years. There are no stormwater controls there, so that was contributing. I think in Mr. Minnick's testimony, he said, well, when it rains hard enough, the catch basin gets overwhelmed. Well, maybe it's raining harder today than it was 20 years ago. But Eastwood did nothing in their development of the property that increased, rainwater leaving their property onto the roadway system.
We have a deferential standard of view, standard of review, is that correct?
Yes, the standard is anywhere in the evidence from whatever source derived any combination of circumstances that could be found from which a reasonable inference could be drawn in favor of the prevailing party.
And the judge took a view in the middle of a rainstorm?
Yeah, it was the summer that it rained every weekend. Anyways, that was a Friday afternoon. My brother was there as well. We pointed out the various drainage structures. We looked at the stormwater drain. The drain did not overwhelm while we were there, but it was raining. And I think, the court saw firsthand the efficacy of the drainage structures that Eastwood had put in place. I think that was, well, I assume that was the basis of making a finding that Eastwood's use of the property was reasonable. And the balance of the property, other than so all the impervious surfaces were lawn area. And in the classic real estate development world of Cape Cod, thick lawn like you'd find off Cape instead of the old Cape Cod lawn. So that, in my experience anyway, would have the effect of retarding the rain from running off into the road. There was nothing, Eastwood did nothing to exacerbate the problem, and that was the goal that the president of the company testified to. The steps they took were designed to minimize the runoff, because they were aware of Mr. Minnick's concerns. So I think and with a finding by the court that the steps that Eastwood took were reasonable, even if there was some harm that resulted, and I don't believe that there was. I don't think the court thought there was either, candidly. The fact that he made a finding of reasonableness forecloses the claim of nuisance, according to the cases that have been decided under this standard. So we think that the judgment of the court was reasonable. It's supported by the evidence that he took regarding the manner in which the properties were developed, and accordingly we think it should be upheld. Thank you very much.
Thank you both. Matter stands submitted. That concludes our business for the day. The court's in recess. Thank you, Dana.